Yes. Huh? Who? Item number 15. It has been submitted that there is a difficulty on the part of Mr. A. Polita, the learned counsel, appearing on behalf of the Industries Department. And accordingly, the matter stands adjourned to be listed on 19th of on 26th of August 2025. Make arrangement.
Make please your lordship. I beg to mention item number 14. With the consent of the other side, on request, I am appearing on behalf of Mr. Shantanu Chakraborty, who is in bereavement. Kindly adjourn the matter for today and fix another date for the same lordship.
Item number 14. We are asking for adjournment for? On behalf of? AG. His name is not appearing?
Sir, for the petitioner.
Okay. It has been submitted that Mr. S. Chakraborty is in bereavement. So considering the above, the matter stands adjourned to be listed again on 9th of September.
Please, your lordship. I beg to mention listing of an item, lordship. Bench for matter.
Why?
Huh?
Why?
Lordship, there is an eviction matter, lordship. There's a matter.
Eviction is, I think, bench 5. Earlier in bench 4. Eviction from where?
Actually, lordship, the land belongs to us, but an eviction notice was issued, but still no action has been taken so far.
So you want to move a motion tomorrow?
The case is already moved, lordship.
Then?
The case is already in motion. We're waiting for admission.
You got to stay.
No, lordship, no stay has been granted.
But I don't think the matter will be before me. Yeah. Go before the next court.
May please your lordship. I'm praying for an adjournment in this matter. The contending counsel has some medical emergency in his family, doctor.
What is it challenging?
Penal damage charge imposed by the railway authorities.
Where is the place where the demurrage charge has been imposed? What is the case out here? Anyway, he is asking for adjournment. He has no urgency. It has been submitted that the petitioner has no urgency in the matter for which the matter to be listed for motion after 4 weeks.
Much of it.
You are? State corporation what? Seed Corporation, okay. Now the tender has been issued by whom?
Assam Seed Corporation has issued the tender, my lord. While filing inadvertently, my clerk was informed by me today, my lord, that copies could not be served upon him. So Agriculture Department usually takes the copies, so the copies of the one. No, I'm saying Agriculture Department has taken the copies, and I'm not saying that. Today morning, my lord, I'll serve a copy on him, my lord. right now.
What is your case?
Yes, my lord. Now, my lord, we are on a very limited footing, my lord. Now, the Food Corporation had published an NIT calling for eligible bidders to participate in a tender process for supply of hybrid seeds, my lord. Now, my lord, while calling tenders, my lord, from 2017 onwards, or in fact earlier than that, when the same corporation used to call tenders, there is a clause in every such tenders of the recent past that the candidates belonging to reserve category are required to furnish, my lord, security deposit or EMD, my lord. So there has always been a concession, always been a relaxation to these category candidates from 2017 and earlier, even till my lord, last year, this concession clause was there. So we are basically aggrieved by the fact that this current NIT in question deletes this particular concession to be given to the reserve category candidates. I am one of the reserve category candidates who is contemplating to take part in this tender process belonging to other backward classes, my lord. Now they, by virtue of this impugned clause, has curtailed my right to get the benefits, and these benefits are in the form of, my lord, I give only 50% of the EMD. I don't deposit the entire EMD. So this is just one example, my lord, and there can be several other concessions which they can, my lord, incorporate. Now, this particular concession is in tune with the policy of the government adopted in 2021 to uplift the economic and conditions and interest of these marginalized communities, my lord. So my only humble submission before your lordship is that this clause has given some kind of a relaxation in the past. So they should.
So you don't have the money for 50%?
No, the question is not about the money.
I'm not on the question. Do you have the money for 50% or not?
It's matter of principle, my lord. And of course, my lord.
Because I'm not going to stay the tender process.
My lord.
Therefore, do you have the money for 50% or not?
I do have, my lord, of course. My lord, the question, my lord, is not the.
We will consider this question later on, whether it is permissible or not.
I'm sorry, no.
But the tender has to go.
But tender, my lord may just come into one aspect of the matter, my lord, that not only this part, there is another part which I am challenging, my lord, is that, my lord, they have given certain qualification criteria for bidders. That these are the qualification criteria which involves, my lord, that for a certain period of year, you need to have an experience in supplying these kind of seeds in 2020 to 21 for 5 years. Then there is the requirement under the NIT that you need to have a financial spending for certain period, like annual turnover of such and such amount. So we were prepared with this particular NIT that we will be required to give these experiences, but suddenly by the corrigendum that they have introduced on 17th of July, they have deleted everything. Now it's an open market. They have deleted all the qualification criteria suddenly.
Now tell me one thing.
Yes, my lord.
They are the tendering authority.
Of course,
They know what is required. Why should the court interfere?
I'm only submitting on the veracity of the work, or my lord, the veracity of the impugned actions they have undertaken, my lord, because they need to justify, because since 2017 onwards, if I may quickly take my lords to the 2017 NIT, why they have.
So what? 2017, they must have got more wisdom. Now, after 8 years, now they are progressing.
Now, in
So,
2024 also, my lord, I will produce.
2024 also, they must have left out something. That is why they have inserted the same now by way of a corrigendum, they are taking it out.
All day.
Are you disqualified because of the corrigendum?
I am disqualified because of I'm not disqualified. I am aggrieved by the fact that.
No, I am asking you, are you disqualified? Because then no locus. First you have the 50%, then you have no locus.
50%, I do have a cause because, my lord, I wanted to be, my lord, have the.
No case.
Kindly, my lord, we come to page number.
No case. These are the two.
Let them participate.
You don't have a copy. You don't have a copy. You have a copy.
I don't
Do you have a copy? Then you made that observation. Okay? Take your seat. Yeah.
Kindly protect us from one aspect.
Mr. Samaria, you must be worried that if I dismiss the petition even without his presence, You may lose out on something.
Those with the morning hour himself, that is dangerous. Only humble request, my lord. They will not finalize the tender. because-
No, nothing doing.
my lord, because, my lord,
You, do you
because-
have the, I'm therefore saying, do you have the 100% EMD? Are you in a capacity to furnish the 100% EMD?
honestly speaking, my lord, we have the capacity.
Fantastic.
Then question is,
Now,
my lord,
the second
principle.
question is, are you
Question is the
disqualified
principle.
because of the
They
collision?
handle today, my lord.
No, this is not a public interest litigation, Mr.
My
Counsel.
lord.
Are you disqualified in view of the collision? Are you?
No, of course not.
Fantastic, no locus.
Because, my lord, they will
I-
have to.
Otherwise, this is a fit case for going before the division bench.
Yeah.
Think about other people of all the scheduled caste community, they have been deprived of that you want. Now, is it your case out here that you need more competition in a tender process? No, is it your case that you want the competition, more competition? Because the lesser the competition is better in a tender process, isn't it? If I'm not wrong, these are commercial terms. So therefore, the lesser is competition is better. Now you want to include a host of other people that they should also participate. Why? Show me your locus for that. Which one? Dismiss?
My lord, may kindly, if they can
I
produce
can
some
advise,
document to show their.
having a
justification.
lot of sympathy on you, I can issue a notice and you give him a copy, spend some money on that. Otherwise, there's nothing out there.
Or alternatively, can it be, my lord, that lordship may direct to consider this prayer, what we have.
No, never. It is the tendering authority. They know the better
Consider,
thing.
my lord, at least, my
What
lord,
do I do with AFCONs?
to consider at least,
No, nothing doing.
because in the previous meeting
No,
also
that
they-
will be, that will lead to a spiraling of another litigation. And thereby giving Mr. Samaria again to come up and say that, look, I have not got a copy. Today, without the presence of Mr. Samaria, we are going to dismiss it. He has not been served the copy, so he can't stand up. Madam, you come this side. Yes. What do you want? Withdraw, dismiss, which one? You don't have a locus, Mr. Counsel. You don't have a locus. You may have a locus as a public interest spirited person out there, go
Admittedly,
before a
my-
PI,
are not denied.
but
an
not
aspect,
in this matter. No locus.
only to the extent of the fact that, maybe if they reduce the amount, some amount of relaxation the petitioners may have in the process of submitting their bid, man, only to that extent, man.
That you have the money, submit it. If you are not successful, you come out. You'll get back the EMD back. Isn't it? Yeah. No problem. You have the money. It is as if safe in the bank deposit. And the most probably the EMD which you are going to submit now, later on, this EMD takes the color out there in the security deposit. That is the rule. So no case.
As a performance bank guarantee, man.
You will
whatever.
obviously give whatever may be, what they are asking for. No case. Which one? Dismiss, withdraw, which one?
I'll take liberty to withdraw it.
Withdraw.
Because it will be,
Heard Mr. H. Buragoyan, the learned counsel appearing on behalf of the petitioner, and Miss Arbora, who appears on the learned standing counsel, who appears on behalf of the agriculture department. Full stop. The learned counsel appearing on behalf of the petitioner submits that, taking into account that the petitioner is in a position to furnish the EMD out of its own resources and is otherwise qualified in terms with the corrigendum, the petitioner would not like to press the instant petition. Taking into, in that view of the matter, the instant petition stands closed on withdrawal.
all right.
Yes, Oil India is on the other side.
Yes.
Oh.
It's in respect of week, 2000 HP week, Actually, we are not readily available. They are imported from US and some parts are from Japan and China. Here, the petitioner, he has got the check, initially
The
tender.
traveler, you are the right person. When you are referring to Japan, China and all, in presence of the person concerned who keeps on traveling. Please. Tell me. Well, you are telling a impugn letter, bearing number and its aftermath.
My lord, on
What is the impugn letter? Where is that?
no, the last impugn letter, my lord. So that is at the page, my lord, 164.
So you have an arbitration clause.
Arbitration is
Go
different,
there.
my lord. Arbitration is different clause, my lord. But here I am coming, my lord. Here what happened, my lord? They have given a, lastly, my lord, they have given a target of 20th June, my lord. So on 13/6, we were informed that we are ready for spudding.
Huh?
We are ready for spudding of the, my lord, spudding. Well, that page 102, if you also see, my lord. Page 102. Page 102, my lord, here.
See what they say out here.
Yeah.
And it appears that you were issued a termination letter on 11/4/2025.
Uh,
And on your request, this was further extended. Then, what is wrong?
23rd, my lord, they have pointed out that these things are to be done. My lord. And
You
we
were
are-
asked,
we are-
you were asked, where is that?
No, we are doing
Communication.
it. 23rd, my lord, yes. My lord, 1 on 2, 1 on 3. 1 on 3, my lord. If you also see, they have instructed us, my lord, that please do these things. The observations of, my lord, are there. 23rd. We have completed these observations, my lord. By 4th of July, almost, my lord, 84% has been completed, and now we have fully completed. 1 on 3, my lord, your lordship. This is a letter of 23rd June, my lord.
Where page?
Page 113. 113.
Yes, what is
My lord,
this?
this is a letter, my lord. These fine attest your observations made by the instrumental section on 16/6 during the inspection. So this inspection was done on 16/6. They have issued some, my lord, observations. These are minor, my lord, because as per the contract, my lord, also, my lord, that can be allowed, my lord, that not, my lord, we have got the entire contract. If you're also to see, my lord, the 27.1, they can allow, my lord, so some minor things, maybe there, my lord, here or there.
What is this?
Well, this is part of the contract, my lord. I'm just
You have not enclosed.
well, entire contract is very big, my lord. I've got
So the part,
I'm
therefore,
having-
you are
I'm having
choosing
that
some
contract.
pages.
I'm having the.
Where is the arbitration clause in the page?
Sorry, my lord, I'm.
Arbitration is there, where is it? That, why that is not there? Why, Mr. Sahiwala, now I should not say that there is a suppression, because arbitration is an alternative remedy.
72 arbitration clause, that clause has been, they have given
Page 70,
72.
72.
And there are some exceptions also, that is also in there.
Settlement, arbitration, everything. Except that otherwise furthered in the contract, if any dispute between question or disagreement arises between the parties to or in respective to entry in connection with the construction and meaning, operation, effect, completion or deeds thereof, which parties are unable to settle mutually, the same shall be referred to as provided. Proceeding can be done by giving 50 days notice to the other party that construction will come up with the same. This is the manner.
Yes, and page 76, Lordship will kindly come. There are
Page,
certain situations which are excluded from arbitration. But the present situation is not covered under the exclusion provision also,
any dispute or
42.5.
dispute relating to connected with arising out of or is be initiated in proceeding for suspension or dischargement or suspending or decision to suspend or to bring or depart business within the district. Any claim difference or dispute relating to
If they are for blacklisting or for giving them holiday. Those things are-
any claim which is placed. So your claim is less than 25 lakhs. That is the only exclusion. No?
Well, not, well, on that, no, not, well, your lawsuit fee, they wanted 7 weeks. Well, they could give only 4 weeks. Now, yesterday also, they have sent a well, email to petitioner as well as some others. They want-
Now, okay, Mr. Sayola, what do you want today? I should do.
Well, see, for the interest of the nation also, my lord.
No,
is
there's
required.
no, interest of the nation
No,
is for the
interest of
Supreme Court to
interest of the
look into.
company. That's all. But you can also see,
I have nothing to
this
do
is
with
the main,
it.
my lord. No,
No, Mr. Sayola, what order do you want now?
I want, my lord, that they should take the risk because they
No,
have-
no, are you asking for stay? Stay for termination.
I mean,
And tomorrow if you lose, what happens?
it's
Now,
a-
if you lose the case, what happens?
they can file immediately,
No,
my lord.
forget about the fighting the affidavit. If you lose the case, because this termination happened on 5/7/2025. We are in the end of this July. So the termination has already been given effect. Now you want me to put the clock back to the date of termination. Meaning thereby, if you lose the case, what happens?
No, I'm not that at least, my lord.
Don't spoil the time
the-
before the court
no,
out here,
second-
better
second order,
arbitration.
Well, at least a second order, my lord, for removal of the rig because your lawsuits fee.
Removal has to be done.
Well,
If you win the
no,
case, you would,
no.
because are you, okay, are you willing to pay the demurrage charges and the loss they are going to have if you keep the drilling machines? If you give an undertaking, then I will give you. Give an undertaking.
I have to work out the figure, everyday loss we are incurring is 21,420 USD in one part and another part is 48,620.
So you give an undertaking, because we'll apply Ronak. You give an undertaking that, look here, I am going to indemnify them if you lose the case.
So, the provision is there, my lord.
Best is arbitration.
My lord, no, your losses, my lord, why I'm submitting, my lord. Yesterday, your losses see the mail given to me as well as others, my lord. Yesterday, and there was a meeting urgently on at 5 PM. And they said that urgently they require rig which should be mobilized by October. Because they are urgently requiring 2 rigs and they wanted to, my lord, give up the other requirements, my lord.
This is on a different
Other quality.
context altogether, Lordship.
Other criteria, my lord.
But this is for other people.
My lord?
This is to be given to another people.
No, we have also invited, sir.
Huh?
We've been invited.
You have been invited. So go, invited, very good.
Present,
So
my lord.
they have not even blacklisted you.
My lord, my lord, that is why I say, my lord, at least, my lord,
I am not going to stay.
for a week, my lord,
No stay, week also, minute also. Minute also I am not going to stay because this goes against my principle. You cannot put the clock back
so removal, my lord, at least removal, my lord, at least,
unless you give an undertaking that you are going to indemnify with what the Mr. D. Soikia says, that 21,000 and 48,000 USD per day if you lose the case.
my lord, your losses may take up after.
Indemnify him.
That email is totally on a different context for others, Lordship.
No,
This is the
then
discrepancy.
I can give him a week's time so that you can file an affidavit, provided if he loses, he has to pay every day from 5/7. 5/7, huh? The terminate, you have been asked to vacate on 7/7. So from 7/7 onwards, every day 21,000 and 48,000.
Okay.
So you have to pay and then you will indemnify him. Done? Instruction.
Deeply oppressed.
Mr. Betala, where are you? Oh, you were there. What is this?
My lord, this is a matter,
You have filed the affidavit in opposition.
yes, and we have filed a reply.
Ah.
This is regarding the stenographers of this honorable high court, my lord. They are in the cadre of class 2B under the rules.
Ah.
And they are to be promoted to the next higher level, class 2A as assistant registrar.
And the feeder cadre is the ministerial cadre and the stenographer's cadre. Well, the proportion which has been fixed is 4:1. That means 4 for ministerial cadre and 1 for the stenographer cadre.
Eastern register, they have 11 posts.
Yes, ma'am.
8 posts is for reserved for the ministerial and 3 for the other.
stenographer.
Then
That is where they are aggrieved, my lord, because the
if it is
stenographer.
4:1, it should have been less than why there is 3.
No, it has to be, that is where, my lord, they want it to be more, my lord.
No, it is already there. If you see the gradation list of 10/6/2025, 24, it will be show that there are 3 stenographers who are from the stenographer stream who have become the Eastern register.
Yes, my lord, and there is another aspect of the matter. They are also promoted to the senior grade stenographer under class 2AA, which has come later on by notification. But from that post, there, under the rules, there is no avenue for promotion to next deputy register, and the pay scale is at par with the.
I am absolutely with you on that aspect. The High Court, Guwahati High Court on the administrative side is failing.
Well,
The rules have been framed horrendously. Is a post, you may see out there, a librarian cannot do not have a right for promotion to a higher post,
Exactly.
whereas the assistant librarian can do so. I understand. It's horrendously done.
They are in a stagnated position, my lord.
Very well. But have you ever approached the High Court
Yes,
on the
my lord.
administrative side?
We have filed a representation.
And the High Court is sitting on it.
Yes, my lord. They have said
Why are you sitting on it?
subject to outcome of this writ petition.
No, why?
Writ petition has been.
No,
filed. It was-
first of all, if you see Rule 2, as per Rule 7.3,
Yes.
Rule 7.3 says that there are 3 classes. There are three feeder category. The first would be from the State Judicial Service. The second would be from classes from 2A, 2B, 2C, and 2D. Now, 2D is not there in Schedule 1. So that is to say, and the third is an advocate having a practice for 5 years.
Yes.
You are not including the senior stenographers. Why? A stenographer who is junior, the selection got, you have these 3 type of stenographers. no?
It's
Senior stenographer was created, a separate cadre was created to facilitate promotion of the private secretary. Because
But
they submitted.
Understood, but from there, a person who is there in that grade is not the feeder category to the Eastern Register. I can't do anything on the judicial side because this is absolutely within the wisdom of the Chief Justice under 229.
Their
But-
ratio is unfair. 4:1 ratio is that is.
No,
the best
ratio, I'm
case.
not on that. I'm not on that. But why do you exclude those people who has got a promotion from senior stenographer to senior stenographer grade A or something?
Yes.
Whatever it may be. Why you are not excluding them?
From being. a
You
feeder
are
post of
creating
assistant-
post, a higher post to give a promotional avenue to the senior stenographer.
Yes.
But that promotional post is not the feeder post to the post of so-and-so. Meaning thereby a person who gets a promotion loses out to become an Eastern Register. Isn't it?
Have to check, my lord.
It is so. Kindly see. No, kindly see Schedule 2A.
Because 67, there are, after that, my lord, lots of decisions were taken.
How can you keep on having decision after decision without amending the rules? Unless Rule 7.3 is not amended, you cannot.
That's
So have you challenged the rule? You should challenge the rule as to be arbitrary. Go before the division bench, challenge 7.3. Then only the High Court on the administrative side will learn what is actually required to be done pursuant to judicial orders passed by the same judges.
that aspect of the matter. Thinking, my lord.
You should.
Yes.
Don't keep
At the
on
time of
thinking. You have
filing
been
this-
thinking for the last 2 years.
because of
Now,
our,
as regards the ratio, you have a problem with the ratio. The reason why you have a problem with the ratio is 2B is only those stenographers stream,
yes,
whereas 2C, although the High Court on the administrative side has a very soft corner for the AOJs and has completely debarred the court officers, the protocol officers, and all those who come under 2C have a very, it's a stepmotherly treatment the High Court does. But then also, there are 6 categories in 2C. So obviously, there will be the ratio has to be more.
but
Although the High Court only gives the preference to the AOG.
that way we are. facing
But
steps.
whenever the High Court has some good feeling about some officer, they take a different stand. Just see the judgment of the division bench in the case of Niroj Sharma versus that person concerned, where the High Court stand is specifically that this person, although he had a rider out there, was promoted to the post of protocol officer, and therefore he comes under 2C to be considered for under section 7.3, rule 7.3a.
Still-
He only made that submission. Isn't it?
At present,
There is
our-
only one person in the entire High Court who got that benefit, isn't it? You have taken somebody outside the AOJ to become a promotional from to the post of secretary. He's the only standalone.
that was.
High Court on the administrative side.
That was on the basis of record.
Huh?
On the basis of, records of that case,
There is no records. The records are same. The same aspect is everywhere. But here, he's the only standalone, isn't it? He's the only standalone case whose appointment has been considered to be a substantive appointment as per the High Court on the administrative side. And that matter went to the Supreme Court upheld it. So therefore, take a clue from that judgment and go to the division bench, challenge the rule 7.3.
On the other hand, our representation which is pending, which has not been disposed of by the registry, on the ground that my case.
The registry cannot dispose of the representation. The representation
to
has
the
been
CJ.
disposed of by the Chief Justice
Yes, ma'am.
in
Under
view of the
rule
Article
56.
229. It is the Chief Justice who is the all-in-all boss.
That may be placed for the CJ. and
So therefore, you need to challenge the rule.
After passing of the, after disposal of my petition.
No,
sorry,
if
my-
they don't dispose of that, then you always you can
Yes.
challenge on the ground that the High Court is not inclined to dispose of my rules representation. So my right to be considered for promotion, which is a fundamental right under 14 and 16,
Yes.
is being affected.
Yes.
So I need not make you more clever. So you take an adjournment today. Fantastic. Mr. M. Khatunia, the Learned Counsel, appearing on behalf of the petitioner, seeks for an accommodation today. To list the matter on when we'll finish it off. Next day it is finished. In the meantime, if good sense prevails on 21st of August. Oh, this is a very complicated matter. Have you filed the affidavit?
No, my affidavit has been filed, but private respondent has filed an affidavit. But copy has not, I haven't received a copy, my lord. Affidavit, no. It's not on the record. I have only yesterday.
So this is as regards the accountant. Now, as per you, what it is?
Last time you looked, equivalence of.
I've asked you to file an affidavit. What happened? You are not filing it.
After that, my lord,
From the state company, therefore,
Another
clear that there is
order
no
was passed.
decision taken by the Guwahati High Court on the administrative side as to whether the post of the accountant would be the feeder post to the post of Harrison. This court have also perused the materials on record, and from the materials on record in the case of the petitioner, it is seen that the petitioner was initially appointed as the lower division assistant by so and so. The government of Assam in the judicial had created 158 posts of so and so. Or then I mentioned about interchangeably this was being used, no?
And
The question therefore arises whether the petitioner in man as well as the private respondent in the present facts can be denied their right to be considered for promotion, which is a fundamental right. This court to deal with the say respect on the next day, taking into account that any decision in the present proceeding would have an impact on the appointment of the respondent number 5 in the as the respondent remains unrepresented. Yes,
I filed affidavit, but
we have filed.
not. Copy I have.
So what to do?
Let the- Get affidavit. Yeah, earlier case lottery. While passing the order, there is a service rule also. That was not considered.
Huh?
There was a service rule
What service rule?
regarding my appointment. My appointment was in person, so when. I will, it is in the affidavit also.
Oh, he wants that not to say anything more.
No. But if the affidavit is not there, then it is, why it is
So
not
that's-
copied?
Don't worry.
There is,
I can very take a very copy of that affidavit.
I don't do without that. So that's
But it
why.
is in the draft copy lot.
Yes, what is this?
It is the affidavit lot.
No, tell me whether the post of the accountant, the High Court or the administrative side have not taken a decision as to whether the post of the accountant would be equivalent to UDA. As regards your thing, you were a UDA. You were given the promotion to the post. Okay. Now, if you were given the promotion to the post, so now what are you saying that the infraction to the rule?
It's counted.
But the question is, have you seen my last order? They have interchangeably used a very UDA has been made an accountant.
But here, the last order, this service rule was not considered. Lordship.
Which
The-
one?
The Government of Assam Judicial Department, Assam Chief Judicial Magistrate Establishment, Ministerial Service Rules was not considered.
What was that?
Here itself, Lordship, it is specifically stated in the same service rule. By following this service rule, I'm being appointed. It is all in this this affidavit. Lordship can take up on Monday. Lordship, it will be clear.
Understood. That is the problem.
No, Lordship, this was in the last order. it was not
Well, let me take the benefit of the Advocate General being present in the court. Mr. Soikia. You see, this is a case, I'm just telling you what has happened. We are having a 1987 rules of the district establishment, district judicial establishment, which means the district and session judge establishment. And we have a chief judicial establishment rules of 1987, where it manages all the ministerial stuff for the establishment of the chief judicial ministry. Now, for the last 8 years, it is pending with the government. As regards the finalization of these rules, every time they come up, recently, the finance has given an okay to the draft rules. Now, after everything is being done, now these draft rules are made under Article 234. So when it is being made, it is a rule made by the governor. So the legislative department makes the rules. And then it is forwarded to us for consultation to the High Court. After the High Court gives the report out there, says okay to that, then the finance had some problem. This finance has given the concurrence. Everything has been done. Now, after everything has been done, with meets and bits of everything, now the legislative department comes up and says, hey, look here, these rules have a lot of faults because the preamble should not have been given. Because in rules, there is no preamble.
But it started from the judicial department.
The legislative, because the rules have to be made by the legislative department. Because now the secretary of the legislative department, whoever, he thinks that this is not proper. Secondly, now what happens? What is the idea behind these rules? Because now what has happened? In this case, you have the post of UDA. This is there. Now the UDA is the promotional post to the post of head assistant. Now in the meantime, what happened? The government have created many posts. But these posts have not been amended because there is no amendment to the rules. So the problem which is happening is these posts cannot be, just for example, the post of an accountant. Now the post of an accountant is not encadred. But the government has made these rules and they are still there. Now these people are working, and the district establishment also, district session judge also treats this post as a UDA and interchangeably uses it. Because there were, and these accountant posts more particularly came only in respect to 3 districts, which were 158 posts being created, 3 districts, that is all these districts coming under the Boroland. So these accountants were being brought in. Now these accountants, those who were LDA, they were promoted to the post of accountant. Now they don't have any promotional thing, although they are actually a UDA.
There is the highest post in that line is
Head is still,
head is.
and the highest post is the administrative officer who is there. Now all these things are happening out there. Now if you can put your good word and get the rules done, because everything from the finance, it has got the concurrence, everything. If the rules can be done, because if the rules takes care of this situation, the post of accountant has been brought, the promotional avenues, all these things are being taken care of. Everything has been done. And in fact, the finance is also given a concurrence. Now the legislative department frames. Now
Okay.
what?
Give one line observation in today's judicial order. I'll take it forward
There is already in another matter I have given an observation.
on the
Where-
same issue.
Exactly, and in fact, I was taking up that issue in a batch of writ petition where what has happened, the LDA is the feeder post to UDA. Now there were a lot of posts being created, copyists and all these things.
I think
Computer
only
typist.
thing is that they have to collate the new post with the existing,
Now
they have to
these,
collate the number of
now
vacancies.
all these 7, 8 posts have been created. Now by way of that, the governor have issued a notification, thereby saying that these people are equivalent to LDA or UDA. Given it. And this is being put to challenge, because the question is, without an amendment to the rules, how can you do that by way of a notification in that regard? Because these are all, because you have to encadre these people.
But Lordship is saying that there is a already a rule. That-
No, we
that
have
rule is
already
different.
2 rules,
At 87 rules.
87 rules. Now from 2018, 17, 8 years, last 8 years,
So this is
17.
amendment, which is.
No. A new rule has been made out in 2017, thereby merging the district establishment, the district and session judges establishment and the CJ. And all these new posts which have been created have been encadred, everything has been done. So these rules, everything has been done except now the legislative department has put on this problem.
I'll take care of.
I'm fixing, I fixed the matter on 31st in that other matter, other case. You just put in your good word, may help this quarter to get that rules done. When the finance is given an okay, I think there is no
That is the
problem.
last burden. is
That's the
all
last, that's the last,
Until-
once you cross that, you're in heaven. That is what you say in state of Assam. So kindly look into that aspect of it. Anyways, I'll fix this matter again on 31st. And we, 31st of this month, we'll fix this matter because the other matter is also there. On 31st out there,
Next time I'll have it. discussion
you ask your new additional advocate general.
with Nayak.
No, Mr. B. Gogoi.
The finance is not the problem.
Finance is not a problem. Finance is okay.
For other issues,
Yeah.
P Nayak is the right person.
He is
Can
there.
dig to any level.
And the finance has given an okay. When finance has given an okay, there now what happens if the legislature, because finance were putting certain hurdles in its regards each and every word in the rule. Now this has come okay. After that, now if the legislative department says that all these rules have whatever with a lot of flaws out there, they have put out 20 flaws. Then where is the question of merger? Because the new rule concept is that you will have one district establishment, district concession, wherein the CGM will come under it. So everything is being done in that.
Merger will always have that kind of issues, but that will, in amendments, we can always do that.
Yes,
time to
anything can be done
Education, we
later
have
on.
done the same merger, and there was a clause that in case of any difficulty in subsequent amendments, we'll rectify it.
Now the problem which is happening in this case is I'm just giving. You have created these 3 accountant posts in these 3 districts. Now the district judge of Buxa district considers the post of accountant equivalent to UDA and promotes this person concerned as head assistant. That is one. The chief judicial magistrate of Buxa considers it otherwise and says this UDA, the accountant cannot be equivalent to UDA, and therefore he cannot be given the promotion. So therefore there are 2 petitions. One is by Mr. K. Sharma and the other is by Mr. Eviction. So where both cases are diagonally opposite. So therefore the question is where it is. I've asked the High Court says that we are still considering it. I've asked the government says as the pay scale of a UDA and accountant is same, for us both are equivalent. This is what the government says. But the problem only arises is how to do it. And the district judge as well as the chief judicial magistrate treats both otherwise as UDA because they were promoted from LDA. Because LDA, there's no promotion to accountant because accountant does not have a feeder category because the rules are not there.
For channel also.
Accountant does, because you have created a post, but there is no feeder category. So therefore, these people promoted these LDAs to accountant, and now they cannot go anywhere. So kindly look into this. Okay, Mr. P. Sharma, appearing on behalf of the respondent number 5, submits that the affidavit in opposition has been filed. However, the same is not on record. Lists this matter on 31/5/7/2025. Full stop. In the meantime, the petitioners would be at liberty to file the reply if so advised. Oh, fantastic. The reply, Mr. K. Sharma further submits that the petitioner have filed a reply. So accordingly, both the affidavit in opposition of the affidavit in opposition of the respondent number 5 as well as the affidavit in reply filed by the petitioner be brought on record. You are not appearing. Okay. You want to withdraw the case?
Maybe destroy my lord, I have terminate.
Okay. Item number 11. Mr. K. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Taking into account the above, the writ petition stands closed. Interim orders past any stands vacant. Mr. H.K. Das appearance for the guardian. Yes, Mr. Sahiwala.
That the development, my lord, the management wanted to talk to the, my lord, authority, my lord. So it may fix on next week, my lord.
Withdraw. Next week again I am there. I am not there after 2 weeks. The management may require 2 weeks.
This, my lord. I'm not for that.
Chalo, the learned counsel.
If it is, if Lordship is accepting their prayer, then let it be on Wednesday next week.
Mr. G.N. Sahiwala, the learned senior counsel, submits that the petitioner herein is in talks with the respondent authorities in respect to the termination of the contract, and as such seeks for some accommodation. Pusto, list this matter on 30/7/2020.
My submission may be recorded that whatever the negotiation is going on, it is not relating to this issue. There are some other issues where other contractors are also involved.
Mr. D. Saikia, the learned senior counsel appearing on behalf of the Oil India, per contra, submits that the negotiation, if any, as per his instructions, is in respect of some other contract. Because taking into account that as the petitioner have sought for accommodation, list this matter on 30/7/2025 for motion.
Much earlier.
What it is?
I am telling here, order passed by the appellate authority, appeal filed under section 127 of the Electricity Act.
Then
That,
appellate authority confirmed it. Why there are two
modified,
petitions?
my lord, modified.
One petition you have filed.
No, my lord.
Oh,
My
both.
lord, both, my lord. Subsequently, I have challenged the appeal also. my lord.
The appellate authority had
My lord,
directed
earlier,
the judicial to revise the assessment amount. The second petition is against the revised.
in the bill only.
Then the first
Second
one
is against the bill.
order,
Second is only against the, but the first is,
against the order of the appellate authority.
so if that first one is not interfered with, second one has no consequence. Let's take up 81 then. Yes, what is your case? Order, appellate authority. Okay, so and
What
so.
are you-
Now first tell me what are the facts?
Fact of the case is that, my lord, on the petitioner is a consumer of the appeal, my lord,
Ah.
and running tea factory, my lord, and tea garden. My lord, on 18/5/2020, 24/5/2018, a team of appeal officials has conducted an inspection, my lord, and they have prepared a report. In according to that report, my lord, they have found total connected load of 804 kilowatt, having sanctioned connected load of 635 kilowatt of the consumer. my lord.
So you had 200 more.
Yes, 169, my lord.
Huh? 169 more connected load.
Yes. And also, the report is held, my lord, at it's at page 40.
And thereafter, they have made a provisional assessment
Yes,
under 126. Now subsequent thereto, they have made the final assessment. Against that, you have filed an appeal under 127.
this high court, but.
And the High Court says that no, nothing doing, go under appeal, and you filed a 127 appeal. Appellate order being passed against you, therefore you are before this court. These are the short facts. Now, what is your grievance?
Then basically, my lord, the appellate authority held that the inspection team has not inspected the metering system, my lord. The appellate authority considered that it is a minor defect, it is not major defect. One, and secondly, my lord, the inspection report shows on the total.
Did you challenge the inspection report, inspection?
Yes, I have challenged the inspection and the.
Now, how do you challenge the inspection in a 127 appeal?
127, no, my lord, earlier when I had filed a writ petition, my lord.
And that
because
writ
of the-
petition, and the writ petition did not say anything as regards the inspection. Because the inspection, it is a case of theft.
This is a case of
No, no, no.
So if it is a case of unauthorized use, is he challenging the inspection, the manner of inspection?
he's not challenging inspection.
Ah,
And the inspection process, my lord.
okay, then,
But,
There's no prayer, man.
but my lord, the appellate authority has considered that inspection was in order, my lord.
then,
That, and another, my lord, the grievance is that, my lord, as per the inspection report, the total connected load was reflected as 804 kilowatt. Assessment was made for 1057 kilowatt, my lord. And
1057,
57.
what is that?
My lord, that is my case, my lord,
Ah.
basically. There is another line, my lord, for irrigation purpose that was running from the generators, my lord. The inspection report stated that it can be connected only. Nothing has been mentioned regarding what, how much power consumed, etc., etc., my lord. Later on, when assessment has been made, provisional assessment, my lord, the load reflected as 105.
Let's see the provisional assessment. Where is that?
Page 63.
See. Hmm. Where's the inspection report?
My
Inspection
lord, at
report.
page 45.
Page 45. Detected load is,
Connected to the, my lord,
what is the detected load?
Total
804 kilowatt.
804 kilowatt.
Yes, sir.
Total connected load detected is 804 kilowatt. And what is the
Hanging, my lord.
installed at the consumer to cater power at 6 irrigation points? This 0. kV power supplied with step-up transformer can be supplied either from the available KVAs or generators or from demand. Okay. Then, and what is your connected load?
My connected is, my lord, 635.
You got a sanction load of how much?
747 kVA, that is.
Sanction load is 635. And he was using 804.
The detected load was 804, but as far as the irrigation points are concerned, my lord, the amount was calculated. The unsanctioned load, as far as the irrigation points are calculated, my lord, we'll see. The type copy is at page 46.
Hmm.
There is a reference to a step-up transformer.
What is
Cap
that?
70 so-and-so installed at the consumer premises to cater power at 6 different irrigation points,
Hmm.
50 horsepower into 2 plus 60 horsepower into 4.
Hmm.
So this amount comes to 253.54 kilowatt. Man.
How do you know?
Now this has been later calculated.
Okay, okay. 253 point.
54 kilowatt.
Okay, then
So the total unauthorized usage, the entire amount came to 1057.64, out of which 422.64 is the unsanctioned usage.
how do I get this? What you are
Yes.
saying?
My lord will get this at page 92. This is the order passed by the assessment officer against the objection file.
Oh, that is- detected the total load of so and so. Oh, had detected 1057.
Yes, ma'am. 803 being in the factory premises and 253.54 being the
Okay.
detected load as far as the irrigation points are concerned.
Against the sanction load of 635, that is in excess of Iman in the consumer premises. Out of the 422 Iman of unauthorized load, 169 was detected in the factory premises and in so and so in the irrigation. The detected 253.64 kilowatt load against irrigation network, although sanctioned, but was not released for non-submission of agreement and payment of load security thereof by the consumer. In this regard, it may be mentioned here that the inspection was carried out on Iman in presence of the representatives of the Garden Authority and the inspection was duly signed. Against the irrigation load, it is mentioned that in the year Iman, the DGM informed the Garden Authority that the irrigation load is to be sanctioned as additional load, and therefore, thereafter observing all formalities like execution of agreement and so and drawn attention of demand. Accordingly, as per section 1, a provisional bill was prepared. The serve on the Iman by the bill number so along with provisional inspection order and 15 days disconnection notice dated in connection with point. Due to non-appearance of the general manager at this time, the Garden Authority accepted the extension of the Consideration of all the submissions is found that the objection in question is by the implement of So initially it was some 54 lakhs.
Yes, my lords.
Why did it become 55?
The was provisionally assessed at 54. The final assessment was 55.
Why?
There was certain error in but subsequently, my lords, the appellate authority had in fact interfered with the final assessment and asked the APDCL to revise it, taking into account only the unsanctioned loan.
So this is on 25/6/2016.
Yes. The appellate authority's order, my lords, will find that page 126.
So appellate authority gave it against you initially. For what?
No, my lord.
Kindly see
appellate-
page 101.
100.
This is for another tea state.
Yes, this is with regard to another case.
This is for another tea state. This is
Yes.
not for this one.
Yes, this is the order they are using with regard to a ground of theirs. Here, for the actual order of the appellate authority starts at page 126.
What is 103? Another order.
Yes. Of the AARs.
Yes. And the order is 126.
Yes.
Additional 254 was sanctioned.
Sanction,
Was sanctioned, but the provisions of the ARC electricity supply.
They have not done the
They-
agreement or submitted the additional security.
The security also perhaps they have submitted, but the power line or the additional load was never regularized because they are mandatorily required to execute an agreement, which they have not done. That is the admitted position.
that was could not be done due to the failure of the authority value, not on our part, madam.
But the amount must have come down then.
Yes.
How much now?
Amount, the final assessment, my lords, was the amount was revised
Uh,
and it came to 12,60,000, out of which
How
the
much?
12,60,063 rupees.
And out of which he has
He
paid?
has deposited 50% on the direction of the
No,
owner.
Mayor.
Yes, tell me. So here, 55 lakhs which was done, that was wrongly done, taking into account, that is the appellate orders. But from the facts which appears is this. You had a connected sanction load of 635. During inspection, it was found 1057,
My-
of which therefore there was an additional amount of 422. Your case is, out of this 422, 254 was being used through your DG checks, which there is no denial to the effect. But the reason why you have been put or you have been imposed a penalty is on the ground that the electricity department, on account of there being no sanction to that amount, load up to 54, have been deprived of the fixed charges. As regards 169, there's nothing else. I don't see there's any defense to the fact. So therefore, the consideration is that could they have said about unauthorized use in respect to the 254, isn't it?
Yes, my lord. Regarding my lord, the 169 also, my lord, our, we have challenged the order on the ground that the entire inspection has not conducted in proper way, my lord. But inspection report has stated total 804 and it has been mentioned.
Why you are saying that the
connected.
inspection was not done properly?
My lord, as per the regulations framed by the AERC, my lord, the inspection team has to record that information in a particular form, my lord. But they have not done because at that
Format,
no,
in
my-
a particular format is nothing to do.
my lord,
226 cannot exercise there. I'm not on this format. What is the major thing as regards the inspection?
my lord, I want to submit that the meter, regarding meter, the format has prescribed certain columns, my lord. And
Forget about that. I'm not on that. What is the prejudice to you?
yes, my lord. Prejudice is that, my lord, the inspection team has inspected without recording the data available in the MDI meter, my lord. MDI meter has recorded maximum demand also, my lord. As the recorded demand, my lord, whenever we exceed, penalty has been imposed upon us, my lord. And again, this assessment has been made. Now, when the inspection was conducted, my lord, they have not studied the graph recorded in the MDI meter, my lord. The MDI meter is the scientific system for recording.
Second is in ALC. Now, there is one clause, somewhere I've seen it, that when there is an MDI meter,
Yes,
then you, how it is to be calculated is given. Somewhere 5 point or 8 point something, yes.
Yes, yes, yes.
Assessment of energy. Where is the provision as regards MDI meter?
my lord,
Huh?
my lord, can you see the 2.3, my lord?
2.2.3.
2.2.
2.2.3.
It's 16.
Ah. Contract demand. No, this is not the clause. There is a specific provision how it is to be done when it is an MDI meter.
Yes, my lord, that is in 7.4.
Huh?
I mean,
Clause?
my lord, I'm telling my lord. 7.4.2, my lord. See, where electronic meters are
wait,
installed
wait.
and the load curves are starting
7.4.2.
periodically. 7.4.2.
4.2
That is, it is.
This one, page 88. In case of connection with MDI meter, in case of connection equipped with MDI meter, no assessment shall be made for unauthorized extension over the above connected load as per agreement. Penalty for drawing in excess area shall be levied at 3 times the normal traffic tariff for the portion of the demand exceeding the contracting.
Yes, that is correct, my lord. But I am directly not pointing out to that, my lord, because it was.
Your is a case of unauthorized use
Yes, my lord.
and unauthorized extension.
Not extension, my lord.
This is unsanctioned load.
There's
Exceeding-
unsanctioned
exceeding
load of,
means-
there is an unsanctioned load of 422.
Yes.
Out of 169 was found in the factory. And the other is found out there in
In the irrigation.
it. Now, what argument you are placing out here is on the calculation, not on the inspection.
Calculation also, my lord.
No, what the argument in your case is that they should have looked into on the basis of the MDI meter.
MDA meter. Yes, my lord.
So it is not on the question of inspection. The inspection is right.
Yes.
But the calculation has to be made as per the methodology for assessment of demand charge and energy charge.
Yes, my lord.
That is 7.4.2 Roman 3,
Yes, my lord.
isn't it?
Yes, my lord.
In
And
excess of excess or in case of connection without MDI. So it has to be done as per B, isn't it?
Yes, your lordship. In addition to that, my lord, 7.4.2.1 C also.
1,
1C.
whereby electronic meters are installed and the load curves are studied periodically, the period of unauthorized area should be limited to the exact period as could be determined scientifically.
Yes, ma'am. MDA meter is
Could be
there.
limited.
Huh?
Could be limited to the exact period.
And MDA meter is there in the
The
premises of the.
period of unauthorized use of electricity could be limited to the exact as could be determined scientifically. So you have to do as per 7.4.2 Roman 1 and Roman 3C B.
My lord, 3C actually subsequently came into force, my lord. Even then, my lord, AERC has.
No, the fact that there is an unauthorized use, there is no question. There is no quarrel because of the fact that 169 there was in excess. 169 there was, you see, when they found out that you had the connected sanction load of 635 and there was a 1057 is the total. Now the question is, it's a finding of fact right there that there is an unauthorized use of electricity.
Yes, my lord.
The fact that 442 or 24, whatever may be, was the additional use of electricity beyond the sanction load is not in also quarrel,
My lord, that is.
of which 169 and 254 comes in.
That is correct, my lord. 1 minute.
These are findings of facts. You see, Mr. Counsel, you have to also understand. I'm hearing the matter in a tertiary jurisdiction.
Yes, 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 yes.
I can't touch on the findings of facts unless there is a perversity.
Correct, my lord.
So therefore, if this is the connected load, there might be a case of calculatory
Yes,
mistake as to whether they have performed in terms with 7.2 by taking into account 7.4.2 Roman 1C
Yes, yes.
and Roman 3B.
Yes,
That's the case.
that's the case.
Now, the question therefore can be shortened up
Yes, sir.
and asking him whether they have done it in that manner. And if they have done it in that manner, well and well.
Yes,
If not, ask them to do it in that manner.
yes, sir.
That's it.
That's it. ma'am.
Why should I go more?
Yes.
Mr. Chaudhary.
that calculation,
I'm not on that. I don't know how calculations are made.
Yes.
For me, 2 + 2 is still 5.
whether or not seven.
But for you, you will be knowing that 2 + 2 is 4. So
Yes.
I'm therefore saying whether you have, because these are mandates which you need to follow. Is your calculation in terms with 7.4.2 Roman 1C and 7.4.2 Roman 3B? That's all.
I would need some instructions on that.
This is the long and short.
Yes.
In-
Regarding MD, I want to supply one judgment also, madam.
Oh, don't need. We will ask him and Mr. Chaudhary will help.
Yes, sir.
The epidicial councils are really good. Let me dictate now a short order so that he can get. Heard, Mr.
M.
The-
Sekian.
Huh?
M. Sekian.
I'm sorry, the learned counsel appearing on behalf of the petitioner in both the writ petitions. And Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondent APDCL in both the writ petitions. The petitioner herein have assailed in WPC number 81/2024, the order dated
25th October 2023.
25/10/2023, passed in appeal number 04/2023, whereby the appeal so filed was partly allowed, no?
Partly.
Partly allowed,
Yes,
because they have
what is it?
reduced from 55 to 11, partly.
But order dated, my lord, 8/12.
As well as, and further have also challenged the bill, the demand so made by bill dated,
Order dated 8/12/23.
bill dated
18 January 2024.
so and so, issued following the directions passed in the order dated 25/10/2023 in WPC number 646/2024. From the materials on record, it appears that the findings from the materials on record and the findings of facts which have been arrived at by the learned appellate authority, it appears that pursuant to an inspection being carried out on 24/5/2018, it was found that though the petitioner establishment had a sanction load of 635 kW, but there was an excess/unauthorized connected load of 1057.64 kW. Out of, therefore, as per the inspection report, the excess/unauthorized connected load was
22.6.
22.64 kW. It is pertinent to mention that as per the, it is further pertinent to take note of that in terms with the inspection report, 169 of this addition of this unauthorized excess load was found in the factory premises of the petitioner's establishment, and 253.64 was found in the irrigation. What is that irrigation area, no?
At 6 irrigation points.
Was found outside the factory premises used for irrigation purpose. The impugned order passed by the learned appellate authority dated 25/10/2024, 23,
8/12.
25, no?
8/12, ma'am.
812, well, 812. It will go like that. It will- on top, they say 2510.
On that, my lord, appeal was registered.
Huh?
Appeal was
Or 812 there. It further transpires from the order passed by the learned appellate authority that there was a direction to assess the unauthorized use, to make a fresh assessment on the unauthorized use of the electricity by the petitioner on the quantum of the excess 422.64 kW for a period of 12 months at the double the tariff bracket fixed charge only prevailing at the respective period. Also, the learned counsel appearing on behalf of the petitioner submits that as the petitioner's establishment was connected to a MDI meter, comma, the manner in which the assessment is required to be made have been spelled out in clause 7.4.2 of the AERC, all caps, Electricity Supply Code, and CEA, all caps, Installation and Operation of Meters Regulation, 2004, na? 14,
17.
2017. Full stop. The learned counsel draws the attention to subclause 1, Roman 1, by Roman 1, brackets C, small c, of clause 7.4.2, as well as Roman 2, B, no, Roman 3, B, Roman 3, capital A, small b, of clause 7.4.2, and submits that the assessment which has been made is not in accordance with the said. So therefore, Mr. Saikia, your Therefore, Mr. Saikia, your challenge is only on the calculation.
Yes, my lord.
So nothing to do. So the fact that there is an excess of 422 is not in dispute.
Yes, my lord, I have nothing to do. Yes,
Nothing.
they
So the
have
question
conducted-
is that it should have been done in this manner.
Yes, sir.
Next. Taking into Mr. B. Chaudhary, the learned counsel appearing on behalf of the appeal authority submits that this required certain instruction, that he would require certain instruction taking into account the submission so made had a has a technical submission so made requires some instruction in view of the submission so made by the learned counsel for the petitioner on the aspect as to whether clause 7.4.2 Roman 1 bracket C as well as clause 7.4.2 Roman 3 capital A small b have been followed. List the matter, how much?
Weeks time.
Calculation is very tough. No? Because he's not questioning, therefore I put him a question.
Yes.
He's not questioning on, so the finding of fact, so the first petition has already finished, so the finding of fact is 422. The bill which is being made, that whether the penalty or how it is to be done, has it been done in terms with that? So that it is actually in respect to the second one. List the matter again on when do you want it? 5th, 12th,
Need a convenient.
I am in your convenience. I am here.
Fifth August.
Fifth.
Getting selection and appointment of Jari Karan.
Process server. What is your case?
What?
What is your case?
My case is that, Malad, after the advertisement, the written test was held. And the result was published, Malad, on 1/8/2024, which is at page 37, Malad. In the result sheet, the name of the respondent number 5 reflected under the unreserved category. The roll number PS 0194.
Hmm.
This is the roll number of the respondent number 5.
Hmm.
And the petitioner's name reflected under the EWS category.
Huh?
EWS category.
Ah.
That is the 0085.
Hmm.
Then, my lord, the mark compilation has also been given. In the mark compilation, the petitioner got more marks than the respondent number 5.
Where?
My lord, this is page 41. My lord. Page 41, serial number 5 is the petitioner.
What is the name of the petitioner?
Mohammed Rashidul Islam. He
Okay.
got 59.5 marks.
Ah.
And then the serial number 8, my lord. The respondent number 5, Sherin Musammad Hakik Khatun.
What,
He got
58?
58.
Ah.
But in the input result sheet, my lord, page 39, input result sheet, the respondent number 5 has been selected under the EWS category. And the name of the petitioner kept in voting list.
So you are the highest in the EWS.
Yes. And another
Let us
aspect,
see the advertisement.
but advertisement is at page 25. Page 25.
Process server. One unreserved.
One unreserved, one MOBC, OBC, one EWS.
Then. So you submitted yourself for EWC,
Yes,
EWS.
EWS.
And the respondent number 5 submitted for
For general category as per the result sheet published by the authority concerned,
general category, not on EWS.
not on EWS.
But anyways, the respondent number 5 got lesser marks
Than me,
in EWS.
not EWS, not as a whole. This marks has been given as a whole.
No, in EWS category is also mentioned. Can you look at the page 41? Who is Rasidul Islam?
Rashidul Islam is the petition.
So he got 59.5 marks.
Yes.
And Sherin Mohammed Haki Khatun
Hakik Khatun. She
got 58. So, and the category mentioned is EWS.
Category mentioned here in EWS.
Whatever may be,
Yes.
but as per you, EWS, you are the higher.
I am
Now, where is the result notification?
But result, final result notification is at page 39. Page 30. Page 39, the serial number 3. Sherin Musammad Haki Khatun. She got selected. And the name of the petitioner, Malad in the voting list, serial number 3, under EWS category.
So they say that because of women, they have given.
Yes. Now their contention is that because of the women reservation she got, because in the women category, she got the highest.
How
mark.
many people participate? How many women have participated?
Let us total. I have not the details, Malad. And in that case, Malad, my humble submission is that the women reservation is within the social reservation.
Hmm.
So if within the social reservation, then
So then you
in
cannot,
case of EWS only one person. How can it be the women reservation?
I didn't get you.
Malad, the normally social reservation is vertical reservation and women reservation is horizontal reservation. So women reservation within the social reservation. Suppose मतलब 6 posts for ST. Out of 6 posts, if 30%, then 30% suppose 1 post. So one has to be a nomen. If in the already selected omen 1, then the further omen is not required to be given there. In my case, only 1 post is there. Whether against the 1 post, the omen reservation will be applicable or not.
That PGI's Chandigarh judgment.
Yes, Malat, I have got the Rajesh Kumar Dharia judgment. In that judgment, Malat, something has been described regarding the omen reservation, horizontal and vertical. Para
But,
eight-
the question is, first of all, have they made any just taken because she's a woman, or they had earlier made some quantifiable data
Yes,
by you? Because it is required as per the Women Reservations Act or the rules. Categorically mention how you are going to do it.
Yes.
Have you maintained anything to that effect, or just,
Yes, no, there was.
oh, this is the woman, we are doing it?
No, I have got the minutes, my lord. The minute says, if I may read, my lord. The board further discussed the matter for filling of the post of 3 process servers in the establishment. The process of recruitment for the same was completed earlier, and the earlier board prepared a list of 8 candidates for filling of the said post. As per the advertisement issued for filling up 3 posts of process server, 1 post was reserved for OBC, MOBC category, 1 post was unreserved category, 1 post was from amongst EWS category. The board further noted that there are 16 sanctioned posts of grade 4 employees in the establishment, and as per the government notification, 30% of such posts are to be filled from women category. As such, there are 5 posts reserved for women in this establishment. The board took note that at present there are 4 grade 4 employees who are women are working in the establishment, and thus the board views that the remaining 1 to be filled from women. So that's how, my lord, 1 post was earmarked for women.
Was it prior to or later on?
Now, prior to the selection, my lord. This was the
So why didn't you mention that EWS is for women only?
advertisement says only EWS.
Then why didn't you mention in your advertisement that it was only for women?
But the act is there, it automatically
No,
comes.
no. You have said that because there were 3 categories.
Yes.
Why you are not putting it, the woman in the earlier category? The unreserved category.
Uh,
Then there would have been more people from women participating.
No,
Isn't this
in-
disservice to the Reservation Act? Because you see, then more women would have participated. Don't you think so?
women, my lord, total candidates participated here 133.
So
Lord, I
then
haven't
why
checked up
why
how much-
you have chosen that only for EWS we will give for women, but not for in unreserved or in OC, in the other one? OC is what?
OBC,
OBC?
other category.
other category.
Why you have not chosen? What is the basic reason that for EWS you have to do it?
That doesn't reflect in the minutes.
Obviously, it would not, because this seems to be an afterthought.
No, this decision was prior.
No, this decision was prior. So therefore, they should have said, okay, for EWS, we are doing it. First of
Perhaps
all,
there may be-
the question arises as to whether when there is a question of EWS is there, are you going to have another reservation there?
My lord, there may be representation of women in the other category. Like
You-
for like unreserved MOBC.
That
They're
is not
already,
there.
because 4 are already there. 4 women category candidates are already there in the cadre. So
in
Understood, but for that, why have you chosen EWS? There were 3 posts.
Yes,
Why only for EWS? Beside the point, the
Lordship will kindly point. Look, if I may just read the remaining portion. As per the final marks awarded to 8, candidate with roll number 86 got highest mark against unreserved category, and she is placed at serial number 1 as selected candidate, and candidate bearing roll number 150 secured second highest mark, and he is kept in waiting list in unreserved category. Among OBC and MOBC, candidate bearing roll number 58 secured the highest mark, and he is selected against OBC MOBC category, and candidate bearing roll number 193 is kept in the waiting list against the said category. Among women, candidate
because
bearing-
then why not 193, who is a female candidate? 193 is a female candidate.
193, the candidate bearing roll number is kept in waiting list against the said category. Just check. One 94.
193.
193 is a female, yes,
So why not that candidate being brought in?
because OBC is already filled up.
How do you know?
No, by virtue of this Joleshwar Burman.
Joleswar Burman is male and another is a female. Why Joleswar Burman has was taken, and you did not take into account the women's category there, because the next one, 193, is the female.
Yes,
Then why the female candidate was not given there?
in place of,
Joleswar Burman.
because my lord will kindly see,
Because if the
Joleswar Burman's
reservation
score-
would have been applicable there,
Joleshwar Burman got more marks. We
Yeah.
cannot overlook the merit.
then in that case, the petitioner got more marks.
No. I will kindly appreciate. It's not only about marks.
Then again, you are saying, contradicting yourself.
No, I'm not. I'll just explain, my lord. The petitioner is saying, firstly, that she was not an EWS, firstly. The first contention of the petitioner.
I'm not on
That-
that.
Fine,
Let-
that
let-
can clarify.
You will come
Now-
up with a thing that she is also a
Now, as per the-
EWS.
yes,
I'm
as-
not on that.
As per the minutes, 16 posts were there in the cadre, and the committee found that 4 are already there. So one has to be earmarked for, not, woman. So he has not challenged the advertisement. Now-
nothing has been mentioned.
Advertisement, there is not a single mention to
Nothing
the
has been
difference.
mentioned.
Now this one post was earmarked, for EWS woman. Now, if your lordships.
No. No, one
What is it?
post was only marked for EWS,
EWS,
not
fine.
women.
Fine, one post was marked for EWS. Now, if your lordships kindly consider the merit list at page 41,
Then,
Sabir Ahmed, he got highest mark.
Ah.
He has been selected against the one post of UR.
Ah.
Then Joleshwar Burman, OBC, he has got 57. So he comes in OBC. Now, when comes to EWS,
the petitioner got the highest marks.
petitioner got the highest mark.
Then
but
therefore,
why-
you want to bring in the respondent number 5 because he's close to you. Blue eyed,
No,
there cannot be
not a
otherwise.
fact. Not a
No,
fact.
no, first of all, why, and therefore my question is why the female candidate was not taken into consideration in respect to OBC? Or
Sorry,
you
what-
are? Yeah,
I understand your lordship's query. Milord, for answering that question, Milord, I'll have to get the information or instruction. The other 4 posts, which are already occupied by the Milord women, those women candidates belong to, or those women's employees belong to which category, Milord? That I am not having here.
That is not there because they didn't think it. The court will put that question to them. They think these judges think themselves to be the almighty in their
I'll-
districts.
I
And this
can
is in very
certainly,
well, places like Mankasar, going out there becomes very difficult, so you may think that.
no, I can certainly
You
place
just
that
feel
instruction.
like, okay, here we don't find that candidate. We don't like the face of the petitioner, so better off
That should not
deprive
be the-
him and give it
That
to
should
him.
not be below.
That-
If that has happened, I'll be the first person to
Yeah.
place before your lordship the correct action.
You have filed the affidavit, you could not place them. With the records also, you are not in a position to place them.
No,
Then,
no,
the
in the affidavit-
decision which was taken then, that you will be having it for a woman candidate prior to that, does not reflect that you are going to have it for the EWS.
This question that your lordship has paused, my lord, this question was not raised by the petitioner.
He need
This-
not.
This, I understand, my lord. This simple question is that, it's a single cadre. One post is there only for EWS, so there cannot be, women reservation or, yes, there cannot be women reservation into it, single.
When
cadre
there is a
post.
violation of Article 14 and
No,
16, we can look into it.
Lordship can certainly go into it, but before that, if I place the instruction that those four, women employees, to which category they belong, then the things will be more clear before your lordship. I understand your lordship's query, my lord. Your lordship is questioning that why EWS, why you don't earmark in the OBC or in the UR? And so far as his first contention with regard to,
Now, here it says, the judgment says that if you have already the woman out there in the list and they secure a march in respect to the merit, then the woman will come in. And then you don't have to again look into another woman to fill up the gap, because the woman, on the basis of the basic idea which appears from the judgment, is that in the cadre, there is a requirement of having 30% reservation. So this 30% reservation you fill up by merit, or however maybe you have to fill it up. That is the basis of the judgment. Now here he says that there were total 16 posts in the cadre, of which there are 4 women who are there. So they need another woman. Make it 5. So 5 would be 30%. Is it
Out of Malad,
16?
out of 16, 30%.
How much?
4.8.
4.8.
It stands to 5%,
5.
the round figure.
So they want another woman. So they should have, if they had that idea, why didn't they put it in the advertisement?
But if the decision has taken prior to the advertisement, then they ought to have been mentioned in the
Yeah,
advertisement.
and if a decision is taken,
That has not been.
or is it
mentioned.
because of you filing the writ petition, they have made this backdated? It seems, no? Backdated. Let's see the entire record,
Lord, so far-
including the mark sheets, marks obtained by 133 candidates.
Yes, my lord, it's there.
Is this the entire record?
Yes, my lord.
There's nothing else?
My lord,
I've asked you to produce the entire records by the hour.
My lord, I
So
understand. my
I
lord.
don't need half
No,
of the
But it
records.
doesn't contain the.
I'm not the,
application-
no,
Other-
nothing, because
other-
this has a ramification all.
The merit list, the marks and merit list are there, my lord. Only the application of the petitioner is not there, or the application of all the candidates.
All 133.
Application copy,
Obviously, that will be required. How many women are there? This is a
There-
very important thing.
candidates participate, the number of candidates participants are there. 144, I suppose. Total candidate participate.
In the advertisement, whether there was any mention about how many candidates will be called for interview?
No, my lord.
Huh?
No. It's a, since it's a direct recruitment, my lord.
Huh?
Since it's a DR, it was a DR, so but ratio cannot be fixed that for so and so vacancy, so and so candidates will be called for.
But why only 16, only 8 participated in the interview? Just for example, there is one candidate whose name is Mosomi Bepari.
Yes,
She is an OBC. She got the highest, but she did not participate in the interview. Why? And why only 16 names are there in the interview list and not all?
my lord, perhaps they were shortlisted for
Why?
since 3 posts.
Now, how can you shortlist? Is it mentioned out there in that?
What lordship has found, what my lord, total 16.
Why 16 were only called?
No, it has to be there in the resolution or
No,
minutes.
it has to be in the advertisement.
No, in the minutes.
No, you cannot have it later on. You cannot have that later on.
May it
It
see the
has to
record.
be, the selection proceeding has to be there.
Here has also not been given
Graduate
the
in any
advertisement.
discipline with knowledge of Assamese language. This is the reserved. Fill the application form of imams. Here the resolution you are referring to is where? This resolution? When was the advertisement issued?
Advertisement issued 21/10/2020.
21/10/2012. Today the meeting of the is held in the United States. But the decision as regards women reservation was taken later on.
Yes.
After setting out what are the questions. No,
One
the
possible explanation. my lord.
advertisement is of 21/10/2022.
Yes,
Then the first resolution comes up on 21/10/2022. How the recruitment, what is to be done,
yes.
published an advertisement.
Okay.
Then 5/12/2022, it says that there will be 15 marks for interview and remaining 85 will be written. Then on 13/12/2022, today at a meeting of the is held in the so and was received. Now 13/12 was received from the Honorable High Court in connection with the appointment of the so. The board further resolved that since the selection process of grade 4 are going on, today this board felt it necessary to fix the reservation. So this reservation is made subsequent thereto. For remand at the stage, it is informed by the in charge registrar at present the proceeding for appointment to 18 numbers of grade 4 vacancies are going on, for which 5.4%, that is 30% of the posts may be kept reserved for women out of 18. So this was 13/12.
If I have understood correctly, the law holding the field is that 30% one post comes out for women in this recruitment exercise. So we'll have to give one post to the woman. If we go by the merit list, one UR post by virtue of merit was filled up by one UR. Second, the OBC post by virtue of merit was filled up by OBC. Then remains CWS.
Do you know one thing? This person concerned, the petitioner, have got 59.5%.
I know, Milo.
And if he has got that mark, he is an EWS. He did not get it because the respondent authority selection board thought, after seeing his marks, decided about only in respect to UR. This is what is being said, appears.
Milo,
One, two.
perhaps, Milo, that is not the,
Perhaps no,
Correct.
that is the only
Because
thing.
I just
Vice
explained, Milo.
Chancellor and waiting list for the piece of peon is so and so.
Since we have to,
You notice the candidate name is so and so on second one and different person so and so. Okay. So just for one candidate. Now kindly see on 1/2/2024, it was duly informed that out of 18 candidates, there should be 5.4 candidates from the woman. Okay. Now, what do? In the unreserved category, they fill up 3. In the case of selected unreserved, out of 6, they fill up 3 women.
for the post of
Chokidar and peon.
only.
3. Then in select OBC, they don't. Then SC, they don't. STP, no. EWS, no. And for Chokidar, no. And 1. So that is 4. So they have done 4 there.
Women.
4 women. But why not there more and having it here?
Sorry.
You see, this decision was taken on 1/2/2024 in respect to Chokidar and peon. That there are total 18 posts to be filled up and peon. Because process survey is what? Grade 4? So they say that there are 14 posts, 18 posts to be filled up, of which almost 6 are required. 5.4 is required. This is what they say. And accordingly, they only fill up 4 from our 18 posts.
4 women came.
4 out of 18 posts.
So 2 left. Or
There
one
they
left.
don't feel like doing it.
I think 1 left they have recorded. 1 post can be filled up in the cadre of process server for women.
So therefore they do it here.
In my understanding, it's vacancy based totally. So out of the vacancies, we have to earmark 30%. Here comes one.
Now
post.
here you see why I'm saying this 4. This is very relevant. Out of these 4, all 4 are from unreserved.
Fine.
So now therefore you want to fill up from EWS, not from OBC. Why? Why?
If I can explain, Milo.
Please.
3 posts. One was earmarked for.
No, I'm not on that. You had 18 posts.
Lordship is telling about peon or process.
Peon,
server.
because this is the cadre.
No,
you-
it's a. I
Mr.
understand.
Mr. Counsel, why you are not understanding? This is the cadre. In this cadre, which is of grade 4, you say that there are 18 posts to be filled up. What is being done is, this very selection committee, out of 18, fill up 4 for women, which is less than 30%. Isn't it? Okay. Because they themselves say it should be 5.4. And when they do so, only 4 here, all 4 are from unreserved category. So therefore, in all other categories, there is no woman. Neither in SC, neither OBC, neither ST, no woman.
If I, with all due respect, Milo.
Yes.
uh, its horizontal reservation of women is not vis-a-vis the post, Milo, or the cadre strength. It is always vacancy based.
No.
It's not cadre based, Milo. Look, there is a division bench judgment of this court, Milo.
Show me.
It's vacancy based.
Always vacancy based.
It's not cadre based.
Suppose, my lord, there are 11 posts. And my lord, how many? Yes,
That is what I'll.
it is a compartment that your lordship kindly see open. Suppose there are 4 posts for my lord, open category, and 1 will be my lord, women. And other my lord, there is third my lord, your lordship kindly see in reservation, that my lord, open reservation.
Lord, what happens exactly is that if there are 3 posts, one is earmarked for women, one comes for women, it will go by the merit position. But here in this case, you are the merit list, the top one is UR has been filled up, then comes the OBC. OBC, we have to give preference to the merit.
Why? Not in the EWS merit, not necessary.
No, it is also.
No, I'm asking why
Yeah.
OBC
You know,
merit?
advertisement, we have to fill up 1 post by virtue of woman. Now, if your lordships kindly consider the.
No, first of all, you don't feel, no, Mr. Counsel, why you, I'm not understanding why. There are 18 posts in peon and chokidar.
Hello.
Out of these 18 posts, you fill up only 4 women. Okay, why? Although there are women candidates are there, but you don't fill it up.
For the post of peon and chowkidar.
Peon and chokidar. No, you see that. You have to see. You read me a resolution a few while back. Yes. There you are therefore saying that out of that you require 5. Remember? Where does the 5 come in? Because the 4 is already there from here. Because you fill up only 4 here. And all 4 are from unreserved category. So therefore remains one. But in respect to the 18 which have been the posts which are filled up, you don't do there. You do it in respect to the process server. And take it out for in the EWS.
Ultimately,
Understand?
even if we do for process server,
This is
ultimately it comes
5,
in 18.
5 plus 3, 8.
And so far as the
9,
30%
10,
of 30% will not be calculated on the
11,
basis of 18. We
12,
have to
13.
maintain, you know, the percentage given by the act that how many women will be there in category, but we don't fix earmark the vacancies on the basis of cadre strength. Because this division bench judgment is absolutely clear on that aspect. Nilima Das, Nilima Das.
Mr. Counsel, you were reading about this thing. The selection was made on 22/2024. Page 41.
Yes,
Yes.
it's the merit list, Miller, date of publishing of the merit.
So, but then also it was done on 22/2024. And you were reading me a resolution of 3/6/2024? Much after that?
There,
Much after after knowing what is the merit. Then you are choosing that, okay, now we are filling up this one. So you're picking that EWS will be chosen now here because he has got lesser marks. We want this EWS out there, not in respect to this. Kindly see, you
no,
are
no, the minutes may be on a subsequent date. but
how?
That's not the, because the whole idea.
Now, why have you taken this decision then, after knowing what is the result? I asked you specifically, was this done prior to that or after that? Mr. Das, you specifically told me, no, you said to me, no, you said to me that this was prior to the selection proceedings. This is a case of misleading, Mr. Das. No, you are misleading. That is what has been submitted before the court. Mr. Das, kindly don't try to mislead this court. This is a pure and simple case of misleading. You want to hear it? These are recording. I specifically, whether it was done prior to the selection process, you said yes. This was done
Maybe-
after knowing all these marks.
I was randomly checking.
No,
I was-
when I put you a question, you have to answer to that, and you have made a specific statement before this court that look here, this was before the selection proceedings were initiated. This is
perhaps
of
I made a
3/6
mistake.
2024.
I made a mistake. It's an error on my part, but the records is absolutely clear.
The records
Whatever
is
is
not
there-
clear. It seems that this has been done in this manner.
But I'm
Anyway.
sorry. I'm sorry.
I'll
Because,
record in my judgment now that you have misled this court. The High
there
Court
was
should.
no intention
No,
on my
this is,
part.
there you go. I'm not. This is
While-
a serious infraction, Mr. This is a serious thing
to
which you have done. Don't make submission before this court just for the fault.
I accepted the spots random,
No, you
maybe-
cannot. You cannot. You said that, should I read from the records? This was the, I said, okay, I trusted you for that, and you have misled this court. This is a strong thing which I'm saying. I don't like to say it to the lawyer, but this is a very strong thing which you have done.
Then why would I split? What will I get?
What you are get? I don't
not
know.
get- I will not get
I'm not no concerned what you are going to get. I am not
I
concerned what you are going
perhaps
to get.
mistaken said that, my lord, I withdrew my submission, my lord. I
No.
beg apology before your lordship
No,
also for that.
nothing.
But
I'm-
the,
I'm putting it on in my order judgment. That how you misled this court.
Lord, I can only ask for apology before
No,
the
this
lordship.
is a very serious thing, Mr. Das, you have done.
Had there been-
You see,
I have
when
cleared-
I believe, I normally believe the lawyer when they say. I did
This
not,
will
but
be
I'm
never-
shocked.
This will
This
never
is
be
of
repeated.
dated 3/6/2024
Will never be repeated.
because of the fact
beg
that you have
apology
not
for that.
enclosed this.
Because-
And have these people said that this decision was taken prior to that? Let us see. Affidavit filed by
made a mistake while seeing the resolution date, my lord. Normally, resolutions come before the decision, my lord. But there was no intention on my part.
We'll set aside the appointment of the respondent number 5, but not to give it to you, and asking them to go ahead and fill up with a women's quota, giving the proper advertisement. Because here what they have done is not disclosing this and doing it at a later stage have deprived the eligible women candidates their rights under Article 14 and 16. And we'll record this, what Mr. Hill heard Mr. The learned counsel appearing on behalf of the petitioner. Mr. H.K. Das appears on behalf of the respondent number. Mr. H.K. Das, the learned standing counsel, appears on behalf of the respondent number 2, 3, and 4. And Mr. S. Das appears on behalf of the respondent number 5. Mr. Tiago appears for the respondent number 1. The petitioner herein is aggrieved by the selection and appointment of the respondent number 5 to the post of process server, in spite of the fact that the petitioner secured higher marks in the economically weaker section, the bracket EWC category. Full stop. To appreciate the case set out by the petitioner, this court finds it relevant to take note of the brief facts which led to the filing of the present writ petition. The district and session judge, South Salmara, that is the respondent number 2, 3, had issued an advertisement on 21/10/2022 for filling up of 3 vacant posts. one post was reserved for one post was earmarked for general category, comma. The second post was reserved for MOBC oblique OBC. And the third post was reserved for EWS. There is no mention in the advertisement that any of these posts is reserved for the woman, though was required under the Assam Women Reservation of Vacancies in Services and Posts (bracket close) Act 2005, which was duly applicable. Before moving forward, this court now finds it relevant to take note of a judgment of the learned division bench of this court in the case of Nilima Das versus State of Assam and others, reported in 2018 2 GLT 924. Wherein the learned division bench of this court dealt with আগতে Assam Women Bill লিখিছিল নহয় bracket Act of 2005 dealt with the Act of 2005 and its implications. Paragraph 13 to 17 of the said judgment being relevant is reproduced hereinunder. From the above observations so made by the learned division bench, it is apparently clear that 30% of the vacancies in respect of all appointments to the services and posts in the establishment which are required to be filled up by direct recruitment shall be reserved for women candidate. And the reservation for women shall be inclusive of the reservation provided for scheduled caste, scheduled tribe, and other backward classes, etc. It is further mentioned that 30% of the reservation of the vacancies in respect of women of remaining unreserved category shall be available to the women of unreserved category only. The learned division when further observed that non-compliance with section 4, which is substantive in nature, is punishable with fine which may extend to rupees 1,000 and also liable to face disciplinary proceedings. It is further observed that the legislative intent behind the said enactment is that women in is that to provide for reservation of vacancies for women in services and posts in order to bring women at par with men. Next. Observations so made by the learned dividend bench and further perusal of the Act of 2005 shows that woman that an endeavor has been made that there is wider participation of women in the establishments under the state of Assam, including in the state in the state of Assam, in the establishments under the state government under the government of Assam, including the said Act of 2005 having also been made applicable to the district judiciary, there is also an impetus that the ministerial staff the ministerial posts is also filled up and have wider participation of women and not less than 30%. The respondent number 3 being a district and session judge would be deemed to be aware of this law. And in spite of that, this court finds it pertinent to observe that the advertisement dated 21/10/2022 is completely silent that there would be women's reservation. Full stop. We come back. Huh?
So far, item number 8 is concerned. Taken up on speaking.
Why?
Because I record call for, I have received the record.
Let me pass this order to you. Let's see.
Fine.
Mhm. Not relating to the Act of 2005.
फाइल हो गया ना
It cannot also be full stop. And more
क्या
particularly,
होगा
when the said act have been enforced for the last 2 decades. However, neither from the advertisement nor from the resolutions adopted by the selection board prior to the advertisement, there is no mention whatsoever in respect to the Act of 2005. Full stop. Next. Now proceeding further, it appears that a total of 133 candidates participated in the said selection process. Initiated on the basis of the advertisement dated 21/10/2022. and out of which 27 candidates belong to 27 candidates submitted their applications in the EWS quota. It is further seen from the resolution dated 5/12/2022 that the selection board, prior to carrying out the selection, had set out the selection procedure. In terms of the selection procedure to be adopted, 85 marks would be on account of would be in written examination, and 85 marks was for written examination and 15 marks was for viva voce. Out of the 15 marks, 5 marks each was allotted to each member of the selection board. In the said resolution dated 5/12/2022, there was then also no decision taken as regards the selection, as regards the reservation of women in terms with the Act of 2005. Be that as it may, the selection board in the resolution dated 5/12/2022 fixed the matter next meeting of the selection board on 13/12/2022. On 13/12/2022, when the resolution was, a further resolution was taken by the selection board. That it was necessary to fix the reservation for women in accordance with the Act of 2005. And it was informed. And taking into account the present proceedings and taking into account that selection proceedings were going on for 18 numbers of grade 4 vacancies, 5.4 numbers of posts may be kept reserved for women. The record further reveals that for the post of process server in the three different categories. Though 133 candidates participated, but only 16 candidates were called for interview. First, this aspect, however, is not supported by any resolution adopted by the selection board to the effect that all the candidates would not be called for the interview. Out of the 16 candidates who were called for the interview, only eight participated in the said interview process. Which was held on 18/2/2024. And on the basis of those marks obtained in the written test as well as the interview, a mark sheet of the candidates was prepared on 20/2/2024. The mark sheet contains the names of 8 candidates First, serial number 1 and 2, first, AA2, the said mark sheet being relevant is reproduced here in under page 41. A perusal of a glance at the said above quoted marks compilation would show that in the open category, 2 male candidates were chosen. No, 1 male candidate was chosen. No, is reproduced here in under the page 41. It is very seen from the records that on 1/2/2024, that is prior to the merit list being prepared, a meeting of the selection board had taken place and a select list was prepared. Of 13 candidates, in the post of to the post of peons and chowkidars, post. It further shows from the said minutes that in the general category, out of the 5 selected candidates, 3 were reserved for women. However, in respect to the OBC oblique MOBC category, comma, the SC category, comma, STP category, comma, EDWS category, in respect to the post reserved post for peons, there was no reservation for women. In respect to the chowkidar category, in respect to the chowkidar post, one candidate out of the 2 was reserved for women, was selected as reserved for women. Therefore, out of the 13 posts filled up, comma, 4 candidates were chosen in terms with the Act of 2005 as being reserved for women. It further reveals from the said resolution that the selection board also took into account the results of the written test for the post of process server. And adopted a criteria that only 1.1:5 that only in the ratio of 1:5 resolved that to call for qualified candidates in the ratio of 1:5 for viva voce. And accordingly issued a notification to that effect. First, on 1/2/2024 itself, wherein the respondent number 5, whose roll number was PS-0194, was shown in the unreserved category. The record further reveals that the selection board, in order to select the candidates after the merit list was published on 22/2024, held various meetings. First, on 3/6/2024, a resolution was made by the selection board and in the said resolution, it was adopted that as there were 16 sanctioned posts of grade 4 employees in the establishment, and in view of the Act of 2005, which mandates 30% reservation, which comes to 5 posts to be reserved for women in the establishment. And it was further resolved that as there were already 4 grade 4 employees who are women working in the establishment, the selection board was of the view that remaining 1 was to be filled up from women. In the said resolution, it was further observed that as the respondent number 5, who bear the roll number 194, secured the highest respondent number 5, who was a woman, had secured the highest. She was selected against the EWS women's quota. The relevant part of the notification resolution dated 3/6/2024, being pertinent for the purpose of adjudication of the instant dispute, is reproduced hereunder. Itu eta tahu di. Hikmah kata saya itu. Ikhil. Iya tu eta tikam. On the basis of the said, resolutions so adopted on 3/6/2024. The impugned notification was issued on 4/6/2024. And it is under such circumstances, the petitioner being aggrieved has approached this court, being aggrieved, that he being the higher, he having obtained the higher marks on merit in the EWS quota being not selected, has approached this court by filing the present petition. The learned counsel appearing on behalf of the petitioner, first of all, it is relevant to take note of that by an order dated 22/7/2024, this court issued notice and observed that the selection and appointment of the respondent number 3 or 5, 5, nah? 5 would be subject to the outcome of the petition. The record reveals that the respondent number 3 had filed an affidavit in opposition. Wherein the justification given to the selection of the petitioner, of the respondent number 5 vis-a-vis the petitioner in the EWS category, is that the respondent number 5 amongst the women candidates in all the categories had, in all the 3 categories, have secured the highest marks. The reply has been filed by the petitioner to the said affidavit in opposition. Wherein the petitioner questioned the EWS certificate so issued in favor of the respondent number 5. And further, stated that as the that as each of the category were single post, comma, the question of having a reservation for women in terms with the Act of 2005 does not arise. It was the categorical stand of the petitioner that the Act of 2005 would only come into play when there is availability of at least more than one post in the said category. The respondent number 5 had also filed the affidavit in opposition. Wherein the respondent number 5 supported the stand so taken by the respondent number 2 and 3, respondent 2 and 3 in the affidavit. And that she has been appointed on 6/6/2024 in pursuance to the selection process. And she has also started receiving her salary. A women's reservation act. Women's reservation. Were the learned counsels appearing on behalf of the parties? And have given my anxious consideration. First, Mr. R. Islam, appearing on behalf of the petitioner, has drawn the attention of this court to the judgment of the Supreme Court in the case of Rajesh Kumar Daria versus Rajasthan Public Service Commission and others, reported in 2007 8 SCC 7585 and submitted. What is your submission?
That women reservation is under the social reserve. If the ST or ST OBC, there is a required number, then on the basis of that number, the 30% reservation is there. Not as a whole, the established.
You say that if it is a case of vertical reservation,
Is horizontal.
no, in the case of vertical reservation, if SC or ST, vertical reservation is SC, ST, then in that case, if any person out there getting a higher marks out there and goes to the earlier category, means the general category, then in that regard, you still have to fill up the post of SC.
Yes.
But in respect to horizontal reservation, then the question of a person who is appointed to as the against a social reservation, then in that regard, he has to what? He will get what?
If social reservation is cancelled, then suppose 8% has been appointed. So in that category, the 30% of the women has to be there. If already selected, then the further women need not to take in that requirement. If the 2 or 3 or 1 is shortfall, then that shortfall has been taken up from the OBC category.
Why?
If the shortfall in the OBC category, then the women come to the OBC category.
I don't
But
get
the
you.
rules is very clear, but can you see the rules? Women reservation rules. The schedule. Can you see the schedule?
Yes.
The STP, suppose 10%, 10 vacancies is there. So out of 10, 3 women should be there. And the SC, if 7, then out of 7, 2 has to be there. Then STA hills, 5 posts, then 1.
Here it says 10:3, SC 7, 2, MOBC 27, 8, General 51, 16.
Yes.
There
Then-
we have why in the EWS category only single post. So the 30% reservation would not have been applied. That is my submission.
Where is the judgment?
But at specific judgment I have.
There is a judgment of that. See, PGI Chandigarh's judgment. That is a judgment. When there is a single post, there is question of reservation does not arise. But are they saying that in the EWS, but EWS is not a single category post? Because if you see in the earlier Chokidar, in the earlier posts of grade 4, there are many EWS. EWS is 10%.
Total out of
Isn't it? How are you having out of 16 so many posts of EWS? Really? How can you have so many posts of EWS?
Out of, make just see the-
EWS is 10%.
Yes.
So if EWS is 10%, earlier, you already have an EWS of EWS you have appointed in the case of peon.
Lordship.
EWS is already there. Now you are taking it as a single cadre. Wait for you are taking it as a single cadre. Then how can you have more than that if you have 16?
Total how many, I haven't seen the records, total how many EWS is there?
No,
Earlier,
in the earlier for peon,
yes,
there's only one EWS have been appointed.
for peon one.
One has been there. So are you saying that against each post there will be one EWS?
Cadre strength, 16.
So therefore you are bringing the woman category out here as 16 because here you have 13 and plus 3, 16, which makes it that you have to have 30%. 30%
Vertical reservation.
understood. 30% will be the within the vertical out of 16. So which will be how much? 3? Out of 16, what will be 30%? 4.8. 4.8 or 5? 5. So 5 will be the woman. Understood. Now, how can you have more than, if that is the one cadre,
10% of 16.
16, you will have 2 EWS.
Correct.
Because it's 1.6. So therefore you are having 2. So then 2, how do you have the 30%? On 2?
For the law. In the other categories, my lord. Say for example, ST, there is a requirement as per the act, 2 post of, if we take the rules, my lord. So it says for SC, out of 7, 2 reserved for women. Suppose we got 1 woman and 1 was shortfall. Then this woman will come from the merit list. Whatever merit list is prepared. we
No,
have
no,
to
no,
bring-
that won't come because it is also there here. Only see here what is being
Yes.
mentioned. Only see what happens here.
Uh,
Only see the rules. 3/4.
3, 4. In case of non-availability of adequate number of candidates belonging to women for appointment, the post should be filled up by respective reserved, unreserved male candidate to which the post is mean. In case of non-availability, may I just place one judgment ma'am, for lordship's clarification? Because Saurabh doesn't- Lord, it will assist your lordships, my lord. Distant judgment, my lord. If my lord here, para 23.11 onwards, the honor, this was a procedure followed by the Gujarat High Court, which has been approved by the Honorable Apex Court, my lord. Para 23.11 onwards. Two sets of judgments when
The
before
court
the
then laid out the so and so proper and correct method for implementing the horizontal reservation for women. Number of posts 100. Open category 51, scheduled caste 2, scheduled tribe 17, socially and economically backward classes 20. Horizontal reservation for women 43%. OCs 17.
one, two, three, these are how it has to be filled up. Alright.
So, for list of 100 candidates, usually a list of more than 100 candidates is prepared so that there is no shortfall of candidates and some do not commit for the So step is one. Step one is to this list of women may be included the they belong to SC and ST. They will do so this step two, SC, ST and SCBC will also come in, taking into account that if they are on merit. Because they are
Vertical.
vertical. Two check for horizontal reservation in OC. In step two, OC, if there are 17 women candidates, do not matter. Category does not matter. Women quota of category is fulfilled. Not more than is to be done. If there is a shortfall of women, say 10 women are available in the list of OC category. 7 more women have to be added. The way to be do this is to first delete the last 7 names of the step 2 list. Thereafter go down the step 1 list of the 51 and pick the first 7 women. Category does not matter. As soon as the 7 women from the step 1 list are found, they are to be brought up and added to the step 2 list to make up the shortfall of 7. Moreover, the this gives an idea by which, taking into account that there was no woman candidate and there was a woman reservation to be made, therefore you take back one who is the highest, remove the last. Now, how do you remove the last? There is general one, OBC 1 and EWS 1.
Merit list will be only one merit.
No, they cannot be merit list of 1. These are all single post. Okay. Now, if that be so, why you have chosen not the one from that post, the general category? Why not from the general category? If it is the case of 14, because now you see the total strength is 16. I don't think that all have been filled up. Here only the new vacancies which have come in, not the post. not the post. So therefore, is it against the direct recruitment of every 30% would be woman? Okay. So here, the 30%, why it was done only for EWS? Because the EWS one was the highest amongst all amongst all the women.
Yes.
So she has been brought in.
That is. Because merit will remain there. Because if your lordship see this step three, the most significant line is thereafter go down the step list after item 51 and pick up the first 7 women. Category doesn't matter. It doesn't matter when it comes to women reservation. In case of UR, the category doesn't matter.
So therefore, you could not have taken the woman from the other one.
Exactly. Because OBC is already filled up by a meritorious candidate.
No, not it is not a meritorious candidate because not because of that, because she has got 48.
She is lower in merit.
Not on the meritorious candidate, but she has got 48. So if you take the women's reservation and you want to bring somebody up, you have to take. Now, therefore, the problem, however, arises out here in this situation to apply is all are 3 different categories.
Category may be different, but here we are concerned with the vacancy.
No, understood. Then why not from the for the OBC? Because she is not from the OBC. Because she is a general.
Yes.
No, the reason must have been because she is a general, so she can't be brought in the OBC category. And for the UR category, she cannot come in because of the fact that no,
I'm
not
sorry.
not merit. On account of the fact that you have already 4
Yes. Yes, correct.
from the general category there. But she also is a general.
Yes, but EW.
But you have not challenged the appointment of that fellow, na? Sabir Ahmed.
Because I got less mark. I got less mark than him.
No, if this is to be applied. But without a challenge, how can I set aside his appointment? Where are you saying that the Gujarat model was accepted?
Yes, I'll just point out. Para 43, my lord.
Mr. R. Islam, the learned counsel appearing on behalf of the petitioner submitted that as the EWS, as the post reserved for EWS is a single cadre post, comma, the question of applying horizontal reservation does not arise. First, in that regard, he has referred to the judgment of the Supreme Court in the case of Rajesh Kumar Daria versus Rajasthan Public Service Commission and others reported in 2007, 8 SCC 785. Mr. H.K. Das, per contra, submits that though the authorities concerned ought to have mentioned in the advertisement as regards the reservation for women, but in view of the Act of 2005 already holding the field, comma, it can be always presumed that the said selection, that the advertisement contains always presume that the said advertisement is in relation to said advertisement, the said selection proceedings, the advertisement as well as the selection proceedings envelops within itself the laws applicable. He submitted that the overall position can be seen from the resolution itself, various resolutions as placed before this court itself, which will show that though this advertisement, the advertisement in question was only in respect to 3 posts, but during the same period, contemporaneously, various advertisements were also issued for selection of peons as well as chokidars. Therefore, this selection so carried out were all in the grade 4 category. And in total were 16 posts. Of which 11 were for peons, of which 11 were peon posts, 2 were unreserved, 2 were post chokidar post, and 3 were post process server posts. The learned counsel for the standing counsel for the submitted that a resolution so adopted on 1/2/2024 would show that in the category of peon post, 3 posts were already the Act of 2005 was applied. And as against 11 posts, 3 candidates, 3 women were selected. From the unreserved category. In respect to the Chokidar post, one woman was selected amongst the 2 posts. Therefore, in respect to the process server post, comma, one woman had to be selected, else it would lead to violation of the Act of 2005. He therefore submitted that applying the formula as laid down by, as approved by the Supreme Court in the case of Surya Saurabh Yadav versus State of UP, reported in (2021) 4 SCC 542. The respondent number 5, who had obtained higher marks, who was otherwise a general candidate, but having obtained the highest marks amongst the women candidates in the process server to the post of process server, was appointed against the post of EWS, reserved for EWS. The learned counsel further submitted that as already 4 posts in 4 posts as already, 4 posts were filled up by women candidates from the general category, and as the respondent number 5 was not an OBC candidate, the respondent number 5 was therefore accommodated in the EWS quota where she otherwise belonged. Anything more? This court have duly heard the learned counsels appearing on behalf of the parties. Mr. S. Das, appearing on behalf of the respondent number 5, adopted the arguments so made by Mr. H.K. Das and further submitted and additionally submitted that the petition, respondent number 5, have already been appointed by the communication dated 6/4/2024 and thereupon have been receiving her salary. This court have given an anxious consideration to the submissions so made by the learned counsels appearing on behalf of the parties, as well as the records which were placed, which contained the various resolutions. 2005, have been made applicable by the Guwahati High Court. To the ministerial staff of the establishment of the district judiciary of Assam. Having, under such circumstances, in the advertisement, when an advertisement is issued, it has to be presumed that the stipulations contained in the Act of 2005 and the rules framed therein under is embedded in the advertisement as well as to the selection proceedings. First, let's go, however, for the sake of clarity, however, for the sake of transparency, observes that earmarking of the post reserved for women in terms with the Act of 2005 should be done by the concerned selection authorities. In as much as it would not only appear to be fair and transparent, but would provide wider participation amongst the women to the selection of the said post. And this, and in as comma D, which is the legislative intent. This court further takes note of the resolutions so adopted, so placed before this court during the course of the hearing. And from a perusal of the said resolutions, it appears that the respondent number 3, the establishment of the respondent number 3, contemporaneously were carrying out selection process in respect to post of peon Chowkidar and process server. In total, 16 posts. First. Therefore, the posts which were required to be reserved under the EWS category would roughly come to would come to 1.6. Or 2. And for women would come to how much? 16 divided by 30?
4.8 million.
4.8 or 5. First. While these selection proceedings were going on, it is seen that for the unreserved category, in the post of peon, in unreserved category, three women candidates were selected as against 11 posts of peon. And insofar as the post of Chowkidar, one woman candidates were selected as against 2 posts of peon. The posts which were filled up by applying the reservation of 30% under the Act of 2005. For the post of peon and Chowkidar were from unreserved category. Post. However, taking into account that there was a necessity of having an additional post to be selected from the woman category from the woman in terms with the Act of 2005. The respondent authorities applied selected one of the women against the 3 posts of process server belonging, which were in the 3 categories of unreserved, OBC/OBC, and EWS. The justifications were given in the affidavit filed by the respondent number 2 and 3 is that one candidate had to be selected in the post of process server for the women category from the women quota. And the respondent number 5 having secured the highest marks amongst all women candidates, she was selected. And as she was selected as against the EWS category. Now the question arises as to whether the selection from the EWS category by the respondent authorities, concerned respondent authorities, violates the mandate of Article 14 and 16 of the Constitution. Inasmuch as such a decision was taken later on 3/6/2024. In this regard, this court finds it relevant to take note of how the horizontal reservation is to be implemented as has been approved by the Supreme Court in the case of Suraj Saurav Yadav, Supra. Full stop. Paragraph 23.11 being relevant is reproduced here in under paragraph 23.11 and paragraph 43. Being relevant is reproduced here in under. From the above judgment, it would be seen from the above formula as laid down by the Gujarat High Court, learned Gujarat High Court, and approved by the Supreme Court. It would be seen as to how the horizontal reservation for women is to be implemented. Step 3, as mentioned in the said formulation of the Gujarat High Court, of the learned Gujarat High Court, in the opinion of this court, is applicable. Now, step 3 of the formulation of the guidance by the learned Gujarat High Court, if applied to the facts of the instant case, would show that against the 16 post, there was a requirement of reservation of 5 posts for women. First. The schedule to the rules to the Assam Women Reservation of Vacancies in Service and Post Rules 2005 further stipulates that there shall be 30% reservation in the general category, in the general category. Stipulate that there shall be 30% reservation in all the categories. And the schedule mentioned therein duly provides the details. In the instant case, comma, against the 16 post of peon, chowkidar, and process server. Nine posts were reserved. Posts were for was against. Was in the category, it was in the unreserved category. Comma, semicolon. Two posts were in the EWS category. Two posts were against the OBC category. And four posts were against the OBC category, OBC, MOBC category. One post was against the scheduled caste category. One post against the scheduled caste category, scheduled tribe category, plains. Therefore, comma, appointing the respondent number 5, who was a general category, therefore, appointing another candidate, another woman candidate from the general category would disturb the mandate as stipulated in the schedule to the rules of 2005. In as much as women candidates have already been appointed against 9 general category posts. However, further to that, the respondent number 5, who has secured the highest marks against amongst the women in the process server category, in the process server post, cannot be selected against the OBC/MOBC candidate post. Under such circumstances, the only manner in which the respondent number 2 and 3 can abide by the terms mandate of the Act of 2005 was to adjust the respondent number 5 against the EWS category. First, under such circumstances, this court, taking into account that the illegal the procedure irregularities as already referred to in the earlier segments of the instant judgment being not of such a nature, which affects, which would require this court to exercise the writ jurisdiction, exercise the writ in the nature of certiorari. This court is not inclined to exercise its writ jurisdiction, for which the writ petition stands dismissed. Full stop. The photocopy of the records so produced by Mr. H.K. Das is kept on record and marked with the letter X. এখন আপনি চাইলে হয় একটু
Apply.
দিন। But Mr. Das, next time,
Sorry for
be
the
careful.
Yes, I'm sorry for the inadvertent mistake.
Get the benefit of the modified assured career progression scheme. Because apparently not the case projected in the writ petition was that there is stagnation, no promotional avenues whatsoever. This was countered by the state by saying, because administrative reforms department they filed their affidavit. Affidavit they say modified assured career progression scheme, you are entitled to get the upgradation on completion of 10 years of service, followed by 20 years of service, another upgradation. Now, my lord, it seems that the state administration has not really understood the meaning of MSCP, because these are the drivers of district establishments, that is subordinate judiciary, not the district court establishments in the Arunachal Pradesh. Now, the drivers have only one grade. There is no another grade. When the grade is one, there is the question of upgradation. To provide them the upgradation, there has to be another grade. For example, if there are grade 1 driver, grade 2 driver, grade 3 driver, the entry grade may be grade 3. Then 10 years, you get the grade 2. 10 years further, you get the grade 1. Over here, that is not the case. So High Court correctly understood the position. Therefore, when they submitted the representation, the registry of the Itanagar bench forwarded the representation to the principal seat. Principal seat asked for their comments. In response, the Itanagar bench wrote a letter, which I am placing before my lord. This is the part of the administrative affidavit in reply, our affidavit in reply. And they made it very clear in the affidavit in reply that that is page 85, serial number.
Page 25.
95, 85 has become 95. It is annexure 10 of the affidavit in reply of the petitioners against the counter affidavit of respondent 4. Here, no, serial number is 85. It is letter dated 21/12/2022. I read, with reference to the above, I am directed to inform you that as per Arunachal Pradesh District Court Service Rules 2013, there is no provision of grading for the drivers as sought by the drivers of the subordinate courts of the state of Arunachal Pradesh. However, if so pleases, by the competent authority, their representation may be forwarded to the government of Arunachal Pradesh for consideration of the grievances by amending the rules as has been provided in other states. Now, I am placing the 2013 rules. The 2013 rules are there in the writ petition. My lord, may kindly see page 17 of the writ petition. Now, the relevant portion, my lord, page 23, schedule capital A at page 22. The next page, page 23 thereafter, drivers.
total 13. Pay scale is given. Pay band 2, 5,200 to 20,200. Grade pay 1,900.
Now
This is
tell
the
me
only
whether
grade.
the state government drivers get MSCP.
My lord, state, so far as the state is concerned, my lord, I am not familiar with the legal position.
No,
I do
this
not
is
know.
very pertinent, why I'm asking. What about Rule 29?
Over here.
Yes.
I'll just see. Residuary provision. The conditions of service of the members of the service for which no express provision is made in these rules shall be determined by the laws, rules, and orders for the time being applicable to members of the state civil service in the state holding equivalent grade and post, provided that any rules other than those referred to above applicable to members of the service immediately prior to the commencement of these rules shall continue to apply to. I have understood, my lord, the line my lord is speaking. I'll have to assert in the book. I am not familiar. I've got it. I've got it. I've got it. I have to assert it. If the state drivers are getting it, then certainly they're entitled to in terms of that. But below, then the other question would arise, assuming for a moment, so I don't know the position on the ground, assuming for a moment, if the state, in the state government office, they don't get it, merely because the state government has not made any such provision, merely because the state drivers have not approached the honorable court, that by itself will not be a ground for these people, the petitioner to deny.
No, because you see, they are regulated by the central thing.
Yes. And the state
And
government,
I think they have an MSCP.
yes,
Have a look.
But-
And
but
because
you
these
know-
are district where you don't have the problem with the, because the chief justice having a role out there in 229 does not come into play. So these rules, the pay rules, everything will be regulated by the 309 rules. The ministerial stuff, actually they say to be 309, but in my opinion, it should be 234.
yes, ought to have been, ought to have.
It has been made under 234. And it is made by the governor in consultation, but the power is everything, the pay, everything is to be regulated by the state. Unlike 229(2), which only gives for the High Court, only gives the power to the Chief Justice.
But
So,
you know, I'll look into this. Only difficulty will, if I come to know, if the position is that the state drivers are also not getting it, because the respective state governments have already introduced a graded system in the cadre of drivers. In the Arunachal, if they have not done it, and the Arunachal drivers have not approached the honorable court, that by itself will not be a ground possibly, will not be my submission, then in that point of view, I'll make it. When that situation arises. To deny the state judiciary drivers will not, this kind of benefit. Because once they will also wake up, they will also come before the honorable court. This ought to have been done, because below the state of Arunachal Pradesh, it has accepted the MSCP. Now, once you have accepted the MSCP, you have to implement the MSCP. You cannot implement the MSCP if you introduce the graded pay structure in any cadre. That is the point. But I'll find out. Because if it is there in the state driver's case, automatically will not we get the benefit, my lord can issue the mandamus without any difficulty. Otherwise, the mandamus will be to amend the rule.
that becomes very difficult.
So, that's obviously, but then mandamus can be considered, my lord, I'll bring the precedents. Anyway, my lord, this is an area I have to look into.
And it would be of great help to me, because taking into account it is the rule, when it is the rule-making authority is there's a rule-making rule for making the rules. There is an authority out there. The
High Court to direct the
jurisdiction, the
mandamus.
High Court's jurisdiction is very.
You know, I remember, because I cited HRI judgment, the 5-judge constitution bench, before my lord justice, at that very point of time, justice, our chief justice, my lord, subsequently, my lord made it to the Supreme Court. Oh, it happens these days, I forget the name. He came down very heavily on me. We have to power, don't cite HRI case. Because in HRI, Supreme Court said, the High Court can't issue mandamus. The power is vested in the concerned authority. But below these days, deviations are being made. We have all seen it in so many cases. My lord is a Puritan, sticking to the principles. But it's happening.
Becomes very difficult because for me to give it, it's okay, but the moment I give it, obviously going to go to
Chief
appeal.
Justice Lokur,
and-
not Chief Justice Lokur. I tested the right thing. He just looked at it, Mr. Tiwari, what is this? No. He just kept it aside, dictated the order, did not refer to A.K. Roy.
Because next, if you, like, recently, with the issuance of a direction to the president, there is already a
Yes,
preferential reference on the
it
one
happened.
three.
The
That
order
is on the issue even on the, because we are having on the High Court, we are having a lot of problems. There recently, I was delayed, just for example, if you see Article 229(2), on our High Court, the problem which we are having, and it is very sad to say, that we don't have a pay rules for the registry. We don't have a pension rules for the registry. Pay, pension, leave, allowance, everything has to be made by the Chief Justice. But this has to have the approval of the governor. Now we don't have it. As of now, even after this High Court being there in existence for the last 77 years, we don't have it. Many of the High Courts have. And it was going on a wrong way. Recently, I passed an order to the effect that there has to, because the moment you see this case, there's no problem out there. There are another case out here from Arunachal Pradesh where she is asking that with parity with the secretariat there, some person with the secretariat out there. But the question for this court to pass a direction there is again a problem in view of the judgment of S.B. Mathur, wherein it says it is not for the High Court under 226 because the power is reserved upon the Chief Justice under 229. So it is for the Chief Justice to act on that. And therefore, in another matter, that is the West Bengal case, there the issue was this pay was not being done. And the government was saying on financial exigencies, they are not in a position to that. And the Supreme Court, what they did is say that, okay, we let a committee be formed by the Chief Justice. And on the basis of that committee, the committee will give the report to the Chief Justice, and the Chief Justice thereupon will trestle it out with the state. This is how it has to be. Then recently in that judgment, if you remember, well, the judgment more particularly famous for calling the particular officers, not to call them in the court so much.
That order of the Supreme Court.
But that was actually on the issue pertaining to whether the court, High Court, could frame rules for retired judges getting certain emoluments. So the Allahabad High Court not only directed and said that kindly if you and put this particular chief secretary out there, all this criminal contempt proceedings were initiated, this went out there. But the issue there was more particularly is whether the court would have done that. The court, when it comes to as regards the finance or anything out there, it has to be done with the concurrence of the state. So this and the approval of the governor, which you see in Article 229(2), is only is said to be actually the approval of the state government. So therefore, it becomes a very difficult proposition for this court. But I don't think this is the problem here. Here, because this is done under 234. Although it is only the question of consultation, there is one judgment of the Supreme Court where it says, what do you mean by the consultation? There is a primacy given to the High Court to see, have a more say.
The consultation was interpreted.
So therefore, I don't think there might be a problem, but if you can come within this, because there are a lot of notification of the central
That would be
government.
very easy, I understand. The moment, I come to know that state drivers are getting it, it will be very easy.
I heard Mr. P.K. Tiwari, the Legislative Council is assisted by so and so. Upon hearing the council, and this court, while hearing the senior council, put a query upon the senior council as regards Rule 29 of the Arunachal Pradesh State District Court Service Rules 2019, whereby the service conditions so not mentioned in the said rules of 2013, but which is otherwise applicable to all state civil state state civil services would be applicable to the members of the service coming within the ambit of the rules of 2013. This court inquired as to whether there is any similar notifications pertaining to certain benefits being given, the benefits being given to the drivers in the state services, Mr. P.K. Tiwari, the learned senior counsel, seeks for some time to obtain instructions. Full stop. List this matter. When do you want it?
Or if it may so happen that drivers of some other categories or even in the cadre of PO
Let's have it on.
having similar pay scale.
Let's have it on 21st of August.
Very.
21st of 2020. Affidavit filed. Government.
Ready, Lossi. We may be given at least 2 weeks time, Lossi.
Why?
Oh, to file affidavit, Lossi.
And Mr. Mukpatin, have you filed the affidavit? Mr. Mukpatin, have you filed the affidavit?
Yes, I have filed.
The affidavit, okay. And Mr. Tapin, what is wrong with you? So many times I have given the time for filing affidavit or one.
Lossi is ready, Lossi. Within a week, we will be filing, Lossi.
Mr. S. Tapin, Mr. Mukpatin, the learned senior counsel, who is also the standing counsel of the Guwahati High Court, submitted that the affidavit on behalf of the Guwahati High Court have been filed. Mr. S. Tapin, appearing on behalf of the government, submits that the affidavit is ready and would be filed in a week's time. List the matter on 28th of August 2025, comma. In the meantime, the petitioner, if so advised, would be at liberty to file the reply.
28th August.
All right.
Yes. Service upon respond number 11 is complete. Service report where is yet to be received from the respond number 6. Further, no counter affidavit has been filed by respond number 1. What is wrong this? Mr. Mukpatin, the service upon respond number 11 is not complete. Where is he?
Service upon respond number 11.
Mr. Mukpatin,
Number
I've asked
11.
them to serve a copy upon you.
Here. 11 the final page.
He works in the establishment of the respond number 6. Who is respond number 6? District and Session Judge Bomdila. Mr. Mukpatin.
Yes.
Yes.
Uh,
The
in this
district
case-
and session judge Bomdila have not informed.
No, my lord. Here I'll clarify the position of the case.
Hmm.
We
Why have
filed.
you not filed the affidavit?
No. I have already filed and the betting. I have signed it for betting, and it has already been approved. I have
But have you
filed.
filed it or not, Mr. Patin?
No, I have not yet filed, and betting has already been approved.
Vetting will go on.
Huh.
Vetting has been going on from month of June. We have ended. We are in the month. We are ending our month of
Yes.
August.
No, it
Nearing
is only
August.
because of delay for betting and
Who is vetting so long? Inform the authority upon whom I will ask the authority to be personally present. The person who is vetting.
There is a register, Guwahati.
Oh, register which one?
Means
You have sent it to
we used to send it to the Guwahati High Court. There is a
Understood.
principal fee.
principal seat whom?
Register
Lordship,
general.
they have filed their affidavit today itself, Lordship.
They have filed the
And-
affidavit. Okay.
Today.
Oh, in the
Then,
case of item number
and,
2,
Mr.
we are
Patil, you are
filing
appearing for
today.
somebody?
And item number 2, we are filing today. We have already filed.
No, in the other matter. Item number 3.
Oh, 3. Not yet filed, my lord. Lordship, I'm sorry, I was in item number 2.
So what we do is that get hold of that person. Anyways, the service upon the respondent number 11 being not completed, comma, the respondent number,
In
the
the
registry
item
of
number
the,
3, my lord.
the
item
registry
number
of the Itanagar bench of the Scott shall submit a report as to why service have not been affected till now by the respondent number upon the respondent number 11 by the respondent number 6. First of list the
No, my
matter.
lord. Here in the case, respondent number 6, respondent number 11 have been transferred to Toang. Now she is no more in the Bomdila. Respondent number 11 has been transferred to Toang. She is no longer at the present address. That is
And
at
who is-
Bomdila.
Petitioner, you are there, na? Who is
Yes.
the petitioner counsel?
I am for a petitioner, my lord.
Do you hear what Mr. Patin is saying?
Yes, my lord.
So you give another copy to Mr. Patin.
Yes, I
that-
have already served a copy to.
And now she's in Tawang.
In that case,
Yeah,
my lord,
oh.
I may be allowed
You
to
may
take
be-
instruction, man.
Now, my
Mr.
lord.
Huh?
Now, my lord, I want to clarify some point here.
Please.
Here, respondent number 6, we have already given our Parawise reply, Parawise, and it has been vetted. And it was at that time, the judge who were at Bomdila, now he has it posted as Kuncha. And the Kuncha judge who was there at the time of filing of the petition, he is posted at Naharlogon. And again, the judge who was at UPia, he has been posted at Along.
Mr.
And
Patin,
respond number six.
Mr. Patin,
Huh.
you listen. Here, there is no name by name any person except respond number 11. All are by designation of the office. We are not concerned whether a person is in Khonsa, Naharlagun, Upia. We are not. We are concerned with the office of the district and session judge, Upia, Khonsa and all. So that whoever officer is that, he has to provide the details. We are not concerned about this. The only thing is, the only person by name is the petitioner as well as the respond number 11. Now the respond number 11, you say now she is in where is it? Tawang. If she is in Tawang or wherever it is, get it served through your registry. Ask your registry to serve it. Your register is the register of the Guwahati High Court Itanagar Permanent Bench would be in a position to serve it. There's no problem with him to serve it. Mr. Counsel,
Yes,
you
ma'am.
serve a copy, extra copy to Mr. Patin,
Yes, ma'am.
and he will serve it through the register. The register will do it. Don't worry.
Yes.
It has been submitted by Mr. Mukpatin that the affidavit could not be filed on account of the register in the principal seat have not yet vetted the said affidavit. Full stop. it is further submitted by Mr. Mukpatin that the respondent number 11 is no longer working as the Seristadar in the district and session judge Bomdila, but she is working in the establishment of the district and session judge,
No, this was
district
She-
and session
yeah.
judge Tawang. Tawang, no?
Yes, Tawang.
Tawang. And
CGM,
as such,
CGM Toang,
huh?
CGM Toang, Secretary of CGM Toang.
The establishment of the chief judicial magistrate Tawang, who's taking into account the above, the counsel appearing on behalf of the petitioner is directed to serve an extra copy of the writ petition to Mr. M.B. Patin, the counsel assisting the standing counsel of the Guwahati High Court, so that he can, so that the said copy can be furnished to the register of the Itanagar Permanent Bench. Full-stop. The register of Itanagar Permanent Bench is further directed to serve the said copy of the writ petition to the respondent number 11, who is presently working in the establishment of the Chief Judicial Magistrate
Toang.
Tawang. Full stop. List this matter again for further consideration on 4th of September 2025. Full stop. In the meantime, the respondent numbers 1 to 10 are given a final opportunity to file their affidavit. Full stop.
All right.
Okay. No problem, no. Hey, okay. You too.
Some affidavit has been filed by the government.
Huh? Huh.
Respondent number 5 is filed. Additional Secretary Transport.
4 and 5.
What is there?
There are some communications, my lord. Department of Communications. That's
Where is Mr. Dina?
आइटम नंबर 2 वो कब लिस्ट हुआ है मालूम सुना है
Yes, sir. Kindly come to page 54. Page 54, I suppose. Huh? Page 54. This is an important document which has been written by the head of the Agency of Road Transport, Road Safety.
Head of the lead agency on road safety.
Huh?
Head of the lead agency on road safety. He is the deponent.
Head of the lead agency, yes. In inviting a reference to the subject above, I most definitely like to bring to your kind notice that the Supreme Court in disposing of the MI has directed all state governments to filing of disposal of accident claims and award of compensation in the systematic and so on. So one of the vital aspects of the direction is that the state authorities shall take up develop a joint web portal oblique platform to coordinate and facilitate the stakeholders for the purpose of carrying out the provisions of Iman and the rules in coordination with any technical agency. As the portal, namely integrated where has been developed by the Ministry of for collection of accident data, and another, namely electronic detailed accident report, have been developed for submitting and disposing of motor accidents claims by the investigating officer and by the motor accident respectively. It would perhaps be appropriate to customize the EDAR platform, which will facilitate all stakeholders. Therefore, request you to take necessary action in this to create a platform to facilitate the stakeholder to carry out. So you are asking the secretary to provide you a similar platform. To, what district? This is filed by the transport. I, the letter dated so and so, had written to the Director of Police to take necessary for designation of an investigating officer for motor agent claims in each police station and for their training in respective subject matter in pursuance. Now, by the order nominated the nodal officer in compliance with the sector in respect of road accident. By the aforesaid letter dated demand, the nodal officer in respect of police commissioner so and so have been nominated. This is for nodal officer in respect of police commissioner at Guwahati City and district superintendents of police for all. So they will be the nodal officer. Inspector General has also issued a letter dated in compliance to the High Court guideline in Goham Mohammed so and so to all the district whereby the concerned officers were informed that the form contained in the scenario are to be mandatorily filled up by the police officers investigating the roads and so. And by the aforesaid letter, it was requested to nominate the additional SP headquarters in the crime of the district as a nodal officer. The head of legislation has reason to facilitate to carry out the provisions of the in compliance with them. The secretary to the Iman has issued the instruction to all the district commissioners of India to utilize the district role of managers for training and EDR. Form also appointment assigned to coordinate with the district command of the Ministry of Community implementation of the and the we are also provided with a letter along with the benefit of the what is this number at page 48?
Page 48.
Column number 6, Roman 6, the head of the lead agency. Yeah.
By 24, inform all the superintendent of police Assam to coordinate with the district informatic officer MIC of their respective districts so to ensure immediate implementation of EDAR scheme and SOP we have annexed. And that later, Lochi may kindly come to, that is at annexure 6, page number 58.
The implementation of the aimed at streamlining the investigation and reporting of renewal has been mandated by the Supreme Leader on ensures that all details related to event, including FIR, victim data and Iman are comprehensively recorded, updated, and so on. This is the SOP.
SOP is there.
All entries should be completed, updated in the IRAD, and the FIR details should be updated before proceeding to IDAR. will collect the personal data from the involved residents, so and so, so and so. Now, this, it's been done in 2023. And this document has been issued in year 2024.
SOP logic.
But has it been in effect done anything?
In fact, that paragraph speaks.
Compliance to, let's see the annexure 8
8.
of the mandated way, with reference to the the registering authority is also bound to take action in the matter of verification of the permit fitness. As the police is the first responder in most road accidents and primary investigating agency, it must report such accidents and promptly obtain details relating to vehicle permit, fitness, driver, and so and so for all involved from the district of demand. It is to be followed in every reported road accident. Shall provide the requested details to the police department and their. So this is being governed by the additional secretary to the, he's the same. Okay, he's from the transport department. Okay.
Yes.
Okay, now this, that is one thing. Now what is the police doing?
From Home Department, we have filed the affidavit today.
You file a affidavit?
Yes. I did not bring it from record.
Huh? By the response number? This is by the Home Department, yes. What is their stand?
Indicated fantasy, para 4 onwards.
These are all from the government only, from the head of lead agency only, everything. But what is the government, the home doing?
1, 2, and 3, annexures 1, 2, and 3, these are from the home. Otherwise, others from the
This is by the Assistant Inspector General of Police. Implementation of the DAR was in compliance with the directions in here. To comply with the above directions of here. Then Inspector General of Police are regarding pilot implementation of cashless. This has nothing to do. Then response over EDA for cashless emergency care for emergency. This is primarily for cashless thing. But I'm concerned what they are actually doing. The directions which have been given by the lead, what do you got, the lead authority and all, has been given. What is the stand of the Home Department or the police, the DGP and all? Because you see, what is required is there has to be some notification or anything issued to all the police officers who are concerned out here that you have to comply with this. And this cannot be given by that transport, because the transport authority does not override the authority over the home. The home is there. But what is the home doing?
we have steps taken by the transport department.
That you have done, but what is the home doing? Because the home requires certain strict, there has to be a notification issued to all these persons. Now you have appointed some nodal officers. The nodal officers has to look into it. There has to be implementation by that nodal officer to look into it. And the nodal officer has to direct those authorities, because the first responder would be the officer in charge. Now, what action has been taken by the police head, which is the DGP, or anybody else down the who has been delegated, or by the Home Department, insofar as those officers in charge who are the first responders? So that is the thing where it will happen. Because unless you can very well say on top officials they are, but it has to go to the roots. Any accident happening out there, that accident that the FIR is being filed, the moment an FIR is being filed, the FIR has to be put out there properly. Just for example, in those SP having submitted the DAR, you could see that DAR does not contain many aspects. So all these factors have to be, it seems that the DAR has been just submitted as a formality. It can't be a formality. Everything, and not only that, because what happens if initially the moment the accident happened, the first responder would be not the police, but who will be the officer in charge of the whoever of the police station or the outpost. So that particular person will then immediately have to take it up with three things. First, he has to submit that FIR to the tribunal. One. That is, second, he has to give it to the investigator, the insurance. And if there's no insurance, and the third is the owner. So he will immediately see as to whether there is an insurance or not, and the third is the owner. So these three persons will be given. Then only the district, the what you call the tribunal may ask the insurance to come up with a figure as to whether that is satisfactory or not. And if it is satisfactory, then only things will move. And if it is not satisfactory to the claimants and all, then only this process has to start from the very root. And the root has to be directed in that.
Head of the legal road safety. He is basically what, from the record I could gather, he is basically leading the team. And all the communications from Lottie was saying that the head of the lead agency, he is writing, he is taking.
He no doubt he is doing it. He is doing it for his department, from his department.
I can see.
But does he have the power to say to the officer in charge, all officer in charge, this will be under the DGP or whoever it is. The high official has to issue. Just for example, I'm just giving you a thing. In the case of suspension, there's an office memorandum issued by the chief secretary that following Ajay Chaudhary's judgment and how it is to be followed. Now, there has to be an office memorandum from your side, from your home department or whoever it is, informing this, that if you don't do it, because there is a thing is by which you are patching it up from the transport or the lead authority, all this authority concerned, then this has to be patched up and thereby make these officers responsible if you don't do it. Some accountability somewhere. Now, yes, what the lead authority is doing is a very commendable job. The EDR is a very commendable job. But this will only happen when the officer in charge. Now, you have a nodal authority. The nodal authority would be only a complaining authority if he is not doing it. But have you mentioned to the nodal authority that look here, you have to look into this? So then how will a person will know that this is the nodal authority for complaining also? Because the actual idea behind Gohar Mohammed and those paragraphs which I quoted is gives the responsibility upon the police, the first responder. The first responder has to come in. So this has to be patched up somehow. Because the moment you do it, then what I propose, which I told them also that day before yesterday, you were not present. I will remit this matter back to the tribunals. And the tribunals will keep the claim petitions which have been filed in abeyance till the submission of the DAR. And if the DAR is not being submitted, I give the power in view of Gohar Mohammed's to the tribunal to inquire with the officer in charge under whom the accident happened to submit the DAR. And the officer in charge would submit the DAR if there is an accident to that effect and all. And submit the DAR. The moment the DAR is being submitted, this claim petition gets tagged with the DAR. And thereby we take care of 166.3. But to do that, I need the document or notification by which the higher authority tells the first responders, that is the officer in charge of the police station or the outpost, if you don't do it, there are penalties. For that, I inquire this. Understood? All these things will be done. Everything I've understood. You see, why didn't I mention the moment an FIR is being filed? The moment an FIR is being filed, he will submit an FAR to three persons. First, the owner, second, the tribunal, third, the insurance, if there is an insurance. The insurance thereupon will submit something that we are agreeable to pay this or whatever may be. Then he will make an interim report and then submit, which is called the IR. After that, he will make a final report, which is called the DAR. That I know. Only thing here is, how do I patch up? First, we need the responsibility upon the officer in charge.
Based on 52, logic seen.
Hmm.
These are from the police authority. The IGP CID has issued. Nodal officers have been appointed and
No, that is why you are appointing these people as nodal officer. But the nodal officer is not the first responder.
they have to look into
They will look into it. But how will they look into it? They will look into it, but have something on record. Them also to act. If there is the nodal officer should be given the responsibility to look into it as to whether they are complying with this particular notification.
Yes. But second page, page 53,
Hmm.
you are requested to nominate the additional SP headquarter, additional SP crime of your district who is looking after the crime as nodal officer. A separate order in this regard is being issued. In case of police commissioner at Guwahati, so and so may be nominated as who shall be responsible for ensuring compliance of the central motor vehicles rules 2022 by the police stations. So the 22 rules, it provides
Empower this particular police commissioner of some action against these officer in charge. Once you give them some empowerment, otherwise this will only be in what letter? It will be only in letter. The spirit will be somewhere else. So we need on spirit also. Something so that these police commissionerate can also take action against. So you have understood. I need not mention so much in my order. This court have daily taken, they heard the learned counsel appearing on behalf of the parties. Further to that, heard Mr. D. Nath, the learned counsel appearing on behalf of the Home Department as well as the Transport Department of the Government of Assam. This court further have perused the affidavits which have been filed by the Transport Department and as well as the Home Department. From a perusal of the affidavits which have been filed by the Transport Department and more particularly the various enclosures therein appear that there has been certain active steps taken by the head of lead agency on road safety. Insofar as the implementation of the directions passed by the Supreme Court in the case of Gohar Mohammed's This court, during the course of this court have also perused the affidavit filed by the Home Department, from where it appears that the Inspector General of Police, CID, have appointed nodal officers and have also You have not enclosed that document, no? That
76.
page 53 is enclosure. See the second paragraph. A separate order in this regard is being issued in case so and so. Who will be responsible for ensuring compliance of the so and so, may be nominated and so and so. I've also perused the affidavit so filed by the Home Department, wherein it is seen that certain officials have been made nodal officers for the purpose of implementation of the judgment in the case of Gohar Mohammed versus State of Uttar Pradesh. Uttar Pradesh State Road Corporation, Transport Corporation. This court inquired with the learned senior government advocate as to whether any steps have been taken for any steps, how the implementation would be carried out by the nodal officers, taking into account that the officer in charge of the respective police station or the outpost would be the first responders to the accident. Mr. Dinat submits that he would obtain instructions in that regard for to list this matter on 21st of August 2020, 1st of August 2025 for an update. And if such update, and if any full stop, update, full stop. The interim orders passed earlier shall continue. But this is how I want to patch it up. Once this is done, then all these matters under 166 would stop coming in. Eh? So then for once for all the matters will be over, sad for the lawyers. Yes, where is that? Complaining against response number 7 to 11. Now first show that you are qualified.
Start public querying it yesterday.
No. First show me that you are qualified. Let us see your rejection letter.
That is what. In this case, earlier it was.
No, let us see now the impugn order.
From there.
No, don't start from there. Let us start from backward.
Yes.
Let us follow a bit of take the stand of that.
Yes.
What you call similar to the Middle Eastern tradition of going backwards. Who do? Yes. Let us see the impugn order. Where?
From backward, let's say 410.
Where is the order?
Document is at 410 page.
410.
Annexure A to the affidavit in opposition filed by the respondent number 5.
410. Ah.
410.
Yes.
Subsequently, see from the top. Minutes of technical re-evaluation of Vijay Krishna Gogol as per order of the Guwahati High Court case number so and so against the e-bidding proposal at so and so. Next, based on the objection raised by Gautam Bonia, the following observations are made. Dated 39/24. These two, serial number 1 and 2.
Land revenue certificate, clearance certificate not submitted. Objection, land revenue not found, but land revenue payment receipt submitted. No land revenue certificate receipt can be accepted instead of clearance certificate.
Now, whether this objection found genuine or not, it says no. Now, let's say kindly count to 3, serial number 3.
Wait. Yes. Land revenue clearance certificate. What is that land revenue clearance certificate? No. I think this has to do something with the Bakija thing. How do you recover? When there is an area in land revenue, how do you recover? No, understood. How? Any government due has to be recovered how? By as areas of land revenue. So therefore you say, when there is a land revenue certificate, means there is no dues. Anyways, let us go. Then GST return of previous year not submitted. Only GST registration survey submitted, GST return of last year not submitted. No, whether objection found to be genuine or not. No land revenue certificate. No, as per the corrigendum of the so and so, dated so and so GST return is not mandatory. So one land revenue and this you have gone in your favor.
Yes. Now this three, serial number three.
All pages
All-
of the
all
document
pages
not
of
signed.
document Not signed. Signature of bidder not found on all the documents. That is the objection. Only it says yes. Now let's do this, Lordship kindly see the page 61 of the petition, Lordship. The relevant clause I'll first place, Lordship, regarding this.
Page,
Page 61. Now, Lordship knows that the tender, Lordship, it can be, terms and condition of the tender can be classified as an essential condition for eligibility. And secondly, Lordship, some ancillary or subsidiary, which is to the main object. Now, Lordship, kindly see the clause 7 at page 61. This is a procedure to apply. So this is a procedural part, not the substantive part. Now, Lordship, kindly come to page 62, 7.6.
all
7.6.
pages of the document
pages.
submitted by the bidders shall be signed by
signed
the
by the
authorized
authorized
signature and
signature
shall also be affixed with the bidder's
Yes.
entity stamp.
Now, Lordship, kindly come to the checklist at page 80, Annexure C of the tender document.
Yes.
If Lordship, that in the page 80, there are columns apart from serial number, some basic requirement, some specific requirement, and document required to be uploaded. Now, if Lordship come to the serial number, no, serial number 14, Lordship, page 83. Here, Lordship, the original bid document duly signed and stamped on each page as an acceptance of the terms and conditions of the bid. Then next column is the original bid document duly signed and stamped on each pages. Now, Lordship, if Lordship come to page 140, this is our bid document, 140.
Yes.
So it is signed, Lordship. You
Huh?
that it is signed 140. That as per this, to bind the terms and condition, serial number 14, it is signed 140. Down below, Lordship, Vijay Gogoi. So entire these things are signed as per that checklist.
So you have signed
Yeah.
it.
Substantially signed it, but there are some pages, page number 100 to 115,
Wait. Where you have signed it?
140, Lordship, page 140, as per that checklist, serial number 14.
No. Which pages you have not signed?
Yes, page number 100. These are bid, given with the bid document.
You have not signed here.
Here, Lordship, these are, the signature is not there.
101 not signed. 102 not signed. 103 not signed.
So as
104
per checklist,
not
it is not
signed.
there, Lordship. As per
105
checklist, we have to sign this particular thing only.
Huh?
As per checklist, Lordship, that as per 14, we have to sign the original bid document with the terms and conditions, serial number 18, that we have signed. But these are not specifically mentioned in the checklist. So these are some documents, Lordship.
Forget about the checklist. It is mentioned at 7.6.
7.6 is the clause.
That is a clause. Checklist does not override the clause.
Clause.
Oh, this is your case. Finish.
No.
Then weak case.
But you can see page 59.
Page 59.
Yes. Which document comprises the bid, Lordship? That
Yes.
these are the documents to be read with annexure, this annexure C, Lordship, checklist.
The bid shall be of two parts, technical and financial. Technical bid shall consist of duly filled up application form in A. Hey, Mr. Deka, Mr. Deka, not the other one, the 7 to 11. You'll see, there's one judgment I delivered on this aspect, na? I remember on this that you have to sign. No. Here they have not signed something. I've delivered a judgment on that. Anyways, let us again have a fresh look when nobody is showing their judgment. Yes, then, so this is a weak case.
6.2.6 Lordship.
So that is good. Then next, what is your case?
Yes.
The second is,
Now Lordship, there is a waiver clause is there at page 68.
no, waiver is for them. I have nothing to do.
No,
Where is 410? Next, Annexer E is not submitted in letterhead format.
Getting this. Now here Lordship, clause 19.2. That is at page 68, the waiver clause is there. What my submission is that through the normal tender process, this they have evaluated and they say that we are responsive. Now, this subsequent one, this is unilateral one, it says on the basis of the High Court's order and their objection. So, Lordship, at that point of time, it is why I'm saying.
No, Mr. Deka, let us. You have submitted a tender
Yes.
along with others. You have been held to be successful, technically qualified. There's a challenge to that by filing a writ petition, isn't it? This court passes an order that look here, this representation which is being submitted, I'll not look into it. Let the authority look into it and adjudicate as to whether these are there, because taking into account that the authority is the best judge of the terms and conditions. The authority looks into it too on the basis of directions passed by this court. And the authority, after looking into it, authority finds that they made a mistake. And now, therefore, in giving on the basis of the directions passed by this court, now corrects it. Now, if you agree, you should have challenged the order passed by the High Court earlier, by the coordinate bench earlier before the division bench, that look here, they have passed this order behind my back. This is wrong. You have not. Now, I cannot touch that aspect. So the jurisdiction upon them to look into it is okay. Now the question is of natural justice, giving you whether the pages which is not signed would become signed if you are being heard. That's the answer. Which
Lordship is correct, but Lordship, for a moment, Lordship, let us come to the High Court's order, Lordship. Why I'm saying so?
Let's come to that.
There is a bar, Lordship.
Ah.
There is a bar under the clause that any dispute arising after the terms and condition that cannot be looked into by the deputy collector. That there is a specific bar, and without disclosing this, what submission is made by the department, Lordship, and this please page 325. So it is misrepresenting this order has been obtained. That is our case. Because
understood, but I'm not here in review, Mr. Constable. I'm not here in review. This order remains, till this order has been, it remains, you can have nothing to do. I can't help you.
Lordship, for a moment, Lordship, kindly.
Mr. M. Biswas, oh, he's here. The learned counsel who submits that the petitioner has participated for grant of IMF vessel located here. The grievance of the petitioner is that despite the technical bid of the respondent being defective, the technical bid has been declared to be responsive. He submits the technical. Counsel submits that due to paucity of time and the fact that the financial bid of the is to be open, he did not file any representation prior to approaching the court. Mr. R.R. Gogoi appearing submits the petitioner should have first approached the respondent with a representation regarding Mr. M. said, in view of the consent of the parties, this court is of the view disposed of with a liberty being given to the petitioner to submit a representation with regard to his grievances. Thereafter, the respondent number 3 shall take a decision on the petitioner's representation within a further period of 1 week and communicate the decision to the petitioner. Until the decision is not taken, status with regard to shall be maintained.
Lordship, as per the annexer 6, the responsive, there is a specific date mentioned for opening of the financial bid, 24 24/9/20. On same day, this order has been passed. And what is the submission at paragraph 2? The petitioner counsel submit that due to the paucity of time and fact that financial bid of the bidder is to be opened shortly. That is the date of opening.
But,
Secondly,
but Mr. Dekar, tell me whether the financial bid was open.
no. Now after this court order has been opened, I am the highest bidder, Lordship. I have quoted more than their rest, Lordship. They have quoted 5,55,000 something. We have quoted 12. So we are the highest bidder, Lordship. Now, Lordship, this three, kindly see, Lordship, 3 of this order. Otherwise, this order would not have been passed, Lordship. How it is misrepresented. The RR Gogol Counsel for the Excise Department submitted that the petitioner should have first approached the respondent authorities. There is a bar, specific bar, a tender itself. Approach the specific authorities with the representation regarding his grievances. Now, the counsel for the petitioner also knows that there is a clause barring that. He also
Barring what?
agreed,
Barring what?
barring this jurisdiction of the tender committee. So now, kindly see at page,
Huh? Barring?
barring the jurisdiction of the deputy commissioner, Lordship.
Ah.
That clause, kindly see, if that clause had been placed, the order would not have been passed. 67, Lordship. Page 6.
67, yes. What is that?
15 plus 15, Lordship, 67.
Ah.
15.1. No bidder shall contact the district collector or the tender bid committee on any matter relating to his e-bid from the time of bid opening to the time of letter of acceptance. Now it's come to 73, Lordship. This exclusive jurisdiction is of the High Court. That is why they have filed this petition
Where?
19, 29 at page 73.
Ah.
Any dispute arising out of the bid shall be governed as per the Assam Excise Act 2000 and Assam Excise Act 16 as amended from time to time and terms and conditions of bid and other orders direction issued by the government of Assam from time to time and shall be subject to exclusive jurisdiction of the Guwahati High Court alone. So there is a bar in 15. Then both the council knows regarding this. And exclusive jurisdiction regarding this is at clause 29. So this is misrepresented. Yes, Lordship, they have not said.
I'm not able to get what you are trying to say here. 15.1 says that from the date the bid is open, till the letter of acceptance is here, kindly don't contact the district collector. That's it. And anything done may have some consequences. 1. 29 vests the exclusive jurisdiction upon the High Court. Then what is wrong?
There is no wrong, but that Lordship, the council is saying that it should be sent to the tender committee. Here he doesn't say that this dispute has to be exclusive.
So are you alleging problem with whom? The counsel for the petitioner or for the respondent?
Both,
excited?
Lordship.
So you are saying that this is an order taken by the petitioner,
Misrepresenting.
the respondent, private respondent, with the counsel for the excise department collusively.
Collusively, this order reflects that.
No, the order does not. Order shows to be a very innocuous order. But are you alleging? Are you alleging? Because you see, if the matter would have come before me also, the question here is, there was a direction. There was that you were held to be successful, technically.
Both.
Not financial, that was not open.
No. Both by
Technically.
the petitioner and the respondent of Assam.
Well,
Equally.
you have been held to be successful. So he comes up and files a writ petition and says that, look here, I have not been able to submit the representation, taking into account that the representation, there is lack of time, that there is a likelihood of opening of the bid. Okay. Now the order is being passed on the date on which the opening of the bid would have happened. Okay, but the writ petition must have been filed one day prior to that. So as on that date, when the writ petition was filed, there was no opening of the bid date fixed. Now, Mr. R. Gogoi submits out there, and look here, he has asked and sought for a writ in the nature of certiorari as well as for mandamus. For issuance of a writ of mandamus, you have to demand justice from the authorities and then only you can get it. So he should have approached them, not here. He therefore submits that kindly don't issue a writ in the nature of mandamus or anything, any direction don't issue because he has not approached the authority. The court says that, okay, I'm not going to look into it. Let him submit a representation and this be decided within a period of certain time. Until then, there shall be a status quo. Now you say about Rule 29. Rule 29, Clause 29. Clause 29 do vest the jurisdiction exclusively on the High Court, but for High Court's jurisdiction can only be exercised when there is a demand of justice. And the demand of justice cannot be from the High Court. The demanding of the justice has to be before the authority concerned. So what is wrong? So no case bad. No, this is of environmental degradation.
No, there are other aspects also.
There's no other aspect.
Yes, Lordship. Even I can show from
You did not submit signed papers. Matter over.
that
Yes.
that is waived because that is waived, presumed to be waived because there is a waiver clause.
Where?
And in that Lordship waiver clause at page 68.
What is it?
And Lordship clarification is sought
No, wait.
from us.
There cannot be no
68.
deviation to the terms as laid down in there shall be accepted. So and so.
19.2 Lordship.
Where's the waiver?
19.2.
The technical overseeing the bid reserves the right to waive minor irregularities.
In my
Don't worry, I'll make it major. Then
No,
over.
no.
Then
So
okay,
once
dismiss.
once it is waived, and that is the by way of tender process. Now, Lordship, kindly see, there is a clarification clause at page 71. If this is a major irregularities, they could have sought for a clarification from us, but they have sought a clarification. Even for
You cannot. The question of clarification does not arise because of the fact that you have submitted a tender which is not in accordance with the submission of the tender.
no, Lordship,
For some good reason or the technical bid did not look into that.
A clarification was sought for, my lord, because regarding his name, clarification was always sought for when he was eligible, when he was selected in the first video election. Finally, in technical is qualified. There were some discrepancies in documents. That clarification already was sought for me.
Then,
no,
so
Lordship.
therefore you tried to do it, but now when there is a direction by the High Court,
Yes.
so therefore you looked into it and found that yes.
No, Lordship, the direction from the High Court is not that the whatever they are saying, that has to be distinct. Now, Lordship,
No,
all
the
right,
fact
after
the fact remains that you did not put your signature in the documents which is required under 7
Lordship,
points.
that my submission would be regarding that, Lordship, my submission would be that clause 7 is a procedural part, Lordship.
No,
That procedure,
that is for CPC.
no,
We'll
Lordship,
go when I take
No,
up bench
no.
one.
Lordship kindly,
Not
no,
now.
Lordship kindly appreciate, Lordship,
Now
how it will
I have
affect.
gone
No,
three
Lordship.
categories more.
No,
I
la-
am in bench
Lordship,
four.
Lordship kindly interpret whether it can be
It is
done
not
as
possible.
a
Mr. Decker, the question of Afcons, Galaxy ties my hand there. I can't help you with those. Backbench. Yes.
Lordship, kindly say when they have filed, Lordship, kindly say when they have filed their earlier writ petition, Lordship, in that their bid was not annexed, not disclosed that.
Mr. Decker, I'm again telling you, I cannot touch the order passed by my brother Michael
No,
Taking
that
into
is all right.
account that order
But
can
Lordship-
be only touched by the division bench, that is court number.
But Lordship, in this case, we have placed all the things on record, Lordship. How they misrepresented collusive bid all these things-
Again, you are need to ask for recalling that order.
No, Lordship.
I cannot sit over that order. That order is right. I can't sit on.
No, Lordship, it is on the behest of the respondent number 6. But
Others may go, please. Others may go. The other matters are not there. 5:45, 4:45 is over.
Lordship,
Yeah,
at least,
others may
Lordship,
go. But only thing is, I need to finish the agony of Mr. J. Decca today itself. Others may go.
Lordship kindly say that
You also may go. Your thing also is not required. You may not say, his case is going to be dismissed.
Lordship, this
No case.
no, Lordship. Lordship says that the order Lordship has said that Lordship cannot pass the order. Now, as per the order, fresh representation has been submitted. Court doesn't bar that you should not hear the other side which us. Because once,
I would have, Mr. Decca, I would have said so, that I would have passed an order that look here, and this person have not been heard, kindly hear him and pass that order. But it is not going to change the thing that it will, the color of your Mr. What is your name? Is it? Bijoy so and so.
then in
That, yes, Bijoy Gogoi. The Bijoy Gogoi, the signature will somehow escape and come back and in those tender papers. It won't happen. 7.6, the authorities hold it to be mandatory. I can't touch it. And they made a mistake earlier. Now, you see the Mr. Decca, what mistake you have done is you have not challenged or filed a review against that order passed by Justice that they are misleading and all these things and all. You should have done that. Now, without doing that, now what happens is they get the the authority from an order or a mandamus being issued by a court. And on the basis of that, they do it.
the way they have.
And
proceeded,
somehow you scraped out. Now, without noticing, you scraped out, and now everything is in black and white.
Lordship kindly say, neither the authority nor the court did not given us an opportunity of hearing.
I'm giving you so much. Yesterday also I've heard it. Today I'm also
I'm
giving
not
you.
talking about this case, Lordship, or this case. Prior to this, Lordship is giving us a opportunity of hearing. I'm grateful.
You
Lordship.
can have beyond 5 minutes after the court hour.
Now, Lordship kindly say, even in this process, I have alleged many Lordship, this is fraud played by the private respondent.
I'm not concerned with that.
No, Lordship, one thing.
I'm
Lordship,
not concerned
No,
with that.
I'll say
I'm only concerned whether 410 page is right or wrong. Isn't it, Mr. Gogoi?
So, that this is based on the objection by the private respondent.
Is that not an objection?
Here,
court-
Lordship, 410 kindly see,
Hmm.
based on the objection raised by the Gautam Buni, there is no independent listing, Lordship, on the base. Now, court says make a decision. Here, Lordship, if see, there is no reason at all. Only says that signature.
You need
that-
a high court judge or a district court judge to be appointed in the tender committee that they should write proper orders.
At least some reason, Lordship, and it is a.
Reason? The reason is apparent. 410 is apparent. The reason is apparent that the first two, he says that why his objections have been rejected. The second, he says, then look here, he did not sign in many pages of the document. He says, yes, this is true, then this bid is not good.
Now, Lordship, even Lordship, on whose objection, Lordship? His objection.
Forget about his
Now-
objection. His objection
Now-
comes with the flavor of a push or a push from the order passed by this court.
Now by a proxy has been objecting this. And we also filed a representation before filing this, saying that proxy and various material placed before this court. Now, even if Lordship in this writ petition, the number they have used
Did he respond number 6 participate in the tender process?
as a proxy.
Whatever, did
Yes.
he participate?
Yes,
He was a tenderer,
yes,
so he has got locals. But
Lordship.
no case,
Lordship, our, we
except
have,
alleging,
now, Lordship, yes,
you may have a case,
Lordship,
which
kindly,
may be more very interesting to
Lordship,
hear
that-
some other
that is-
day.
Lordship, that is
Against
apparent.
the collusion of Mr. M. Biswas with Mr. R. Gogoi. We will
Lordship,
hear
that,
on
that from the record itself also, Lordship, kindly see, Lordship. Even Lordship, this, in this proceeding, Lordship, he is using the phone number of the respondent number 7. Even Lordship, if Lordship sees the affidavit, in this proceeding, I have other material, in this proceeding, they use the same phone number into different affidavit, saying that this is my phone number. Now Lordship knows that requirement of this phone number, it is newly implemented. Now, if Lordship sees their affidavits, even in this affidavit, that same phone number of the respondent number 7, respondent number 6 day, this is my phone number. Respondent number 7 also, in the same, this is my phone number. Now, this is on oath, they are saying, Lordship. Now,
So respond number 7 and 11 were all also tenderers.
no, they are not saying that the respondent number 6 is the proxy of the respondent number 7 and to 11.
Okay, it's okay, I'm not there, but whether respond number 7 to 11 are also tenderers?
No,
Are respond number 7 to 11 part of the tendering committee? No. So under such
no,
circumstances,
that is why, Lordship,
He
they are,
may not
they are,
have
they,
the phone
they are,
number.
they are community members after forming the cartel in that thing. And what
they are not in the tender, they are not participating in the
No,
tender.
I am producing some document on the face of record, Lordship, kindly see, for a one moment. For a moment, Lordship, kindly see. Page 185, Lordship,
Absolutely.
for a moment, Lordship, this is, we have placed on the record. Because if we have not,
Any argument,
this is the,
I'll put all your arguments in the
no,
order.
Lordship, this is the
Any
main
argument?
part, Lordship, kindly see.
No. This is
Lordship,
very
The
unnecessary.
payments are made.
Mr. Jayadeka, if I don't submit that, to put that, you get a good ground for filing an appeal.
Let us have that opportunity also, Lordship. Don't defer, Lordship. What moment, Lordship? Now, respondent number 7, Lordship, he is paying on his behalf, Lordship. I'm from the document also.
So what?
That is the cartel, Lordship, that is,
What cartel? He's not a participant to the tender process.
Lordship, kindly see, and he is using this respondent number 6, using the one-shop names of the respondent number 7. Also from this document, Lordship, every document is there, Lordship, kindly see. So, and this collusive bidding is also barred by under this agreement, Lordship. Tender law.
Only respond number 6 was the bidder. Respond number 7
I
to
have-
11. Mr. Deka, respond number 7 to 11 are not bidders.
Hmm,
Okay. How many respondents are here?
Means bidder,
Total?
total 12.
Total 12. Anybody else who is a bidder except the respond number 6?
No.
Others are
No.
not here. So therefore, to have an allegation as regards a collusiveness of formation of a cartel has to be in between or amongst the other tenderers. The other tenderers are not parties to the instant proceedings.
But
You and him. So therefore, other tenderers are not there. Where is the question of collusion?
Lordship, the basis of their objection, our once responsibility.
No,
becomes irresponsible,
Mr. Deka, only one. One thing out of having heard you for another 10 minutes beyond the quotas, I have come to one good thing for you. I can give you an opportunity to submit a representation against him if he is disqualified. Oh, fantastic. That will be
What-
also looked into.
Whatever, Lordship, we filed it, we placed record and on the basis.
No,
of
it's
record,
okay. That's but your case is dismissed.
that-
No, you are disqualified. But if he is disqualified, also on same terms, he should also be disqualified.
Yes. If, but to this point, Lordship, My, no, Lordship, that signature point, Lordship. How,
Signature you are back.
means how it will affect the eligibility of
Oh, it will affect very much. Because of the fact that these documents which you have not signed from page 100 to 115 or 10 or whatever may be, these are documents, tomorrow maybe you may very well say, oh, look here, these are the documents I have never placed. Where is my signature? It is required as per clause 7.6, all the documents should have my signature. Mr. R.R. Gogoi must have put those signatures out there, put those documents. Say, okay.
that, Lordship, that we already filed our representation regarding their irresponsiveness. We have placed various documents here. Now, Lordship, that opportunity may be
Your
given.
case is dismissed. You cannot be considered.
That till then,
Not signing, no? Ah. Ah. You were there? But here, giving an opportunity does not arise here because this is not signed. What is the, Mr. Deka, you are still in prehistoric times. Buddha still is no longer there. Buddha still has gone for a six. After F-cons and all, Buddha still. When did now the High Court under no circumstances can say that this term is directory or mandatory. It is absolutely within the domain of the.
that has been done earlier, Lordship, as per tender process.
No.
Now this.
They have
subsequent-
overlooked it. Therefore, I'm saying, nah, that order, it was a very ingenious ploy to file a writ petition and get that order. The moment that the order is got, this gave a backing. And this. Now, therefore, that judgment which he's also referring to, where I have interfered, that without giving an opportunity, that I cannot apply because there was no backing. This backing of that order is very dangerous. And it must have been the ingenious brains of Mr. M. Biswas. I can do only one thing. At 2 o'clock tomorrow, dismiss your petition. Ah,
That means that.
yeah, you do whatever you
No,
do.
because if.
Why should I look into it? You challenge his. No, are you challenging here? Are you challenging he being given?
But if here,
You are challenging your rejection.
no, his selection,
His selection you are challenging. Why?
because that, and that thing is that.
No, forget about cartel. Cartel doesn't work. And then
Lordship sees, the,
whether his bid is anything improper. But
that is why I want to source few documents. Lordship.
no, don't show me.
Now, he is using the respondent number 7.
So what?
Respondent number 7 is paying because no, there is a requirement. That is why I want to show this document, Lordship, at least 185 that annexer Tripoli.
What does he say?
He, Lordship, given the detail because giving the details of the account and bank is required at page 187. See for a moment, Lordship. If Lordship says it's okay, then I have nothing to say. Page 187, Lordship. Here, Lordship, kindly see 12. He given the Punjab National Bank saving this thing, Lordship. And now, Lordship, kindly directly see to at page 209. 209. 209, he giving a certificate of the bank, Lordship, 209, kindly see. 207, 209, Lordship. He given a certificate from the Punjab National Bank.
Where is your representation?
Representation, Lordship, at 318. Now, Lordship, here he given the amount also. He has 5,50,000. Now, if Lordship, this is the most vital document, 191, page 191.
So this representation has not been considered.
No, because just day before Lordship, we filed this.
This was given on 7th of October.
Now,
And this order has been passed on here. Okay, and
But
when
that was-
when were
then not
you
change,
rejected?
Rejection.
Why didn't you oppose earlier?
No, rejection of the person not communicated to us. They
Huh?
have verbally informed us on 7, it is on pleading. On 7 evening, they have verbally informed us that a repetition was filed and your application is rejected. And we say that give us a copy that says that court says that given to the intimate to the respondent number 6.
Oh, this rejection order you have not challenged. Oh.
Not common, that's the our case, Lordship. Now, Lordship, for a moment, this irresponsiveness of this respondent, kindly see that we have placed in our representation itself, Lordship. If, Lordship, that on basis of their representation, our finding of the responsibilities can be reversed. Equally, on our representation.
I give you a very good idea. Tomorrow I'll pass the order in your presence itself. I will dismiss your petition that your rejection is right, but your representation also should be looked into by them. I am not going to look into.
Only for
Okay, tomorrow, 10:30, 2 o'clock. This is the matter tomorrow. Same order. Mr. Ambitious cannot oppose. Because he took the same order. Mhm. You also cannot oppose. You have taken the same order.
Such fellow, there is no defect in my bid. They even accept.
Okay, very good. Let them do it. Same order. First, reject him. Then you become the only bidder. So therefore, I will only ask the authorities concerned to look into it your bid as to whether it complies with the terms and conditions, and then pass an order to the effect. And give him a hearing in respect to no hearing to look into by them. Because natural justice is foreign into this type of. I pass one judgment on that. Natural justice is foreign. Tomorrow at 2, we dismiss. That order you can get. You have not challenged the order which has been rejected. The only thing, Mr. Dekar, just you have nothing to say. You cannot say much, isn't it, Mr. Dekar? You cannot say much. Mr. Biswas only say that if he is a person who is technically rejected, then can he seek for a direction for consideration of a representation initially having not challenged it? Because he, after that order passed by in the earlier petition, he did not challenge it till then. When he got rejected, then he submitted the representation. So therefore, can he do so? There are many judgments or not. Kindly enlighten me tomorrow.
that. So they are Lordship, why? That why we not file that.
Huh?
We are aware of that.
Which one?
Writ appeal, why we didn't file the writ appeal?
You did not file the writ appeal. Why?
That is.
No, you were honestly believing that your bid was good. No, that must be your answer.
So we
Okay, I would not further trouble your colleagues more by sitting later than 5. Okay, anybody has any problems with their extension of interim orders? Interim order extended? No.